You're live.
Okay, welcome folks. This is House Corrections and Institutions Committee. It is Tuesday, April 14th. And we're starting our week off with some folks from the Council of State Governments. Council of State Governments is an organization that is there to help state legislatures and throughout the country with policy initiatives, whatever they may be. And we've reached out a lot to the Justice Center and the Council of State Governments to help us a lot with correctional policy over the last, I'm gonna say almost 20 years. It's a good 15 years that we've worked with them. So I don't know whether to start with you, David, or Ellen, how you plan on approaching this. So I'll leave it up to you two. Ellen.
Thank you. Thank you, Representative. I would just ask David, and I are thrilled to be here. Thank you for having us. We'll provide as much information as we can about earned good time generally in a broader context and kind of where that policy sits nationally and also its function and utility in different systems. And then our experience and background working on earned good time with Vermonters in the Vermont legislature through the Justice Reinvestment Initiative that took place in 2019 to 2020. So Representative Emmons, really a question for you. Would you like David to start with kind of the big picture on earned good time? Would you like me to start with earned good time in Vermont, which we can do either?
Got the big picture first, and then let's bring it down to Vermont.
Okay,
That'd be
go for
great.
it, David.
Certainly. Happy to do so, Representative Emmons. My name is David Demora, and I'm with the Council of State Governments Justice Center, where I'm a senior advisor. Have had the opportunity to work in Vermont for many years now, and look forward to coming back up again. It's nice to see you all again. I know that we met just a few months ago, also virtually. And I'll just talk a little bit about this concept of earned good time. There's sort of two things. First of all, there's just good time in general, and then there's earned good time. So earned good time means that you have to have done something or not done something to get it. For example, you may need to be involved in some type of programming to have earned good time, or you may need to have behaved well and not had disciplinary tickets and other problems while incarcerated in order to get earned good time. It is a widely supported rehabilitation concept. Between 38 and 40 states have earned good time, so it's pretty widely used throughout the country. And the idea is to reward positive behavior. It helps improve prison safety because people have something to do and people get some kind of reward for behaving well, if you will. It does reduce recidivism. It doesn't end recidivism. There is no way to say that we can have zero recidivism, but it does reduce recidivism. It increases positive outcomes. And there's a variety of ways that people get earned good time. As I said, by behaving well, not getting tickets, if you will, while being incarcerated or having other difficulties. Also through sometimes attending different programs, education programming, vocational training, etc. There are probably 5 overarching reasons why earned good time is utilized throughout the country. The first one is a fundamental one internally inside the facility. It improves prison safety and prison controls. By offering incentives for good behavior, it helps reduce violence and it enhances safety for both the inmates and the staff. Secondly, we have multiple research studies that show that it does reduce recidivism, that folks that are involved in programs and who do well throughout their time in a facility are less likely to reoffend. Again, to be clear, we can't say that that means zero recidivism. There is always some degree of recidivism. We are always looking to lower that number as much as we can through a variety of methods. There are the obvious sort of fiscal pieces. There are cost savings because if you reduce the time people are imprisoned, you're reducing that cost. And as you know, the costs of incarceration are pretty high. It does promote rehabilitation in that it motivates folks to engage in different things and it motivates folks to behave well as opposed to behave badly, as we sometimes see. And it does help with overcrowding, which is a significant issue. That is, and I think Ellen will talk to this. That certainly has been an issue in Vermont, but it's an issue in many states across the country where they're looking at gigantic price tags to build new prisons, and they're looking for other ways to safely manage the population, to not have to send people out of state in some instances at a high price tag, and to have better outcomes, if you will. So they've been around for a while, and I want to distinguish the two. We talk about earned good time, meaning you have to do something in order to get that good time, and that's important. There are states that have just good time, meaning it's just an automatic. And so there are differences again around the country in terms of how that's done. But the vast majority of prison systems in the country do have some form of this that they look at, that they work on as a way to manage the population while they're inside, and as a way to incentivize folks to get the necessary help that they need to do better on the outside. And so when we combine that with other types of interventions, we can lower recidivism further. I always probably harp on this. We're always trying to lower recidivism further. We can't make believe that there's a zero recidivism ever about anything, but we're always looking to lower it and to improve what we do in order to get it lower and lower and lower. It's important for public safety. It's also important from a cost benefit perspective, quite bluntly. And with that, Ellen, I'll let you talk more about Vermont specifically.
Although I would also say, please interrupt us at any time, or if anyone has any questions.
Of course.
We're not shy at all.
Right, so maybe before we move to the Vermont model, are there any questions of David? Brian and then Kevin?
No, I'm okay.
Okay, Brian and then Kevin?
I mean, it's sort of an obvious question, and I don't want to get too into the weeds, but you're saying with certainty that this reduces recidivism. I guess I just want to make sure this is causation, not correlation. And how do you measure recidivism, and how do we know? And maybe that's too darn big, but we're sure about this, right?
We are sure because there are multiple studies out there. We're happy to send some of those over to you so that you can take a look at them, because it does have to be measured. And recidivism is measured by return to incarceration when we're talking about recidivism of people who are incarcerated. There are other recidivism measures used in other instances. For example, there are recidivism measures for people who are on probation, who may then recidivate and get a new probation commitment or an extension, or obviously if they've committed a new crime, they're going to go back to prison. But what they're looking at specifically in this instance is people who were incarcerated who go back to incarceration.
And that can be at any time for any reason, just going back in.
That could be at any time for any reason. It doesn't necessarily mean a new crime. It could mean a violation, a so-called technical violation, meaning something that you or I wouldn't go to prison for, but because we're under parole or probation, we broke the rules, and that was seen as serious enough that we needed to be sent back.
Thanks.
And just quickly, a clarifying piece there, David, when you talk about this reduces recidivism, you're specifically talking about participation in correctional programming, correct? That is the key lever of reduce, or are you also talking about earning time off of your sentence through good time credits?
Well, it's what you do to earn the good time that's relevant, right? And so it's not just earning the good time, it's what you do to earn the good time that is relevant in terms of lowering recidivism. Does that make that more clear?
Yeah.
You learn to behave. Follow the rules. Kevin?
Did I miss, how long have we been using this method in up to 40 states? 10, 20 years? Or how long have we been using earned time as a practice?
That's a great question. I can tell you for sure 20 years because that's how long that I've been doing the work here with CSG. I can't tell you if it's 30 or 40 years. I don't know the answer to that.
I will say
like
it's
Ellen
grown.
froze.
Oh, am I back?
Yeah.
Yeah, we can hear you,
Okay.
Ellen.
Oh, good.
You're
It's
frozen,
definitely. Oh, okay. Let me go off camera and see
No,
if
we
that
can,
helps.
yeah. We can hear you, it's just you are frozen.
The number of states that have some kind of earned good time credit policy has increased. I was just looking at a memo that we had written for the governor's office in January of 2020, where we looked at states that had policies like this in place, including Vermont, which had earned good time as well. And we had listed that there were 25 states with good time policies that are codified statutorily, and that was in January 2016, and that has grown. And the federal prison system also uses an earned good time policy as well. So I can't say exactly when it started, but it's definitely something that has been adopted increasingly in recent years.
And an ignorant question, has there been any correlation, sentence lengths, have they stayed pretty much the same even though we're offering earned time, or are we seeing a change in what the sentence lengths are?
There is no one answer to that. What I would tell you is that I have seen places where the process
Oh, you froze up, David.
increase. Oh, I'm frozen now? Okay.
Yes,
Can you hear me?
Yes.
Yes.
we heard you,
Okay.
but it broke up. So start your statement over again.
So I'll go off camera and see if that helps. There's no one answer to that. It varies on where you are. In some cases, we've seen where prosecutors factor that in and they attempt to get a longer sentence in order to make up for that. In other cases, we've seen no changes in sentencing. And so there's not a one answer. It depends on where you are. And even within states, it can vary from county to county depending on who the prosecutor or the judges are. So there is not a simple answer of yes, it does or no, it doesn't.
But we do know it does affect it. Yeah,
We know it
Okay.
can.
it can. Yeah. Okay, thank you.
So we've had some form of earned time since what I could see real quick, since at least the early 70s.
Mhm.
So it's a practice that's done within corrections. It's a management tool for the security and safety of the facility, also to give initiatives to folks who are incarcerated to behave and abide by the rules. Simple terms.
Mhm.
Other questions of Dave before we move on?
Yeah, actually,
Kevin?
I'm sure it varies, but what percentage of individuals do not earn time? I mean, does pretty much everybody earn it? Or is it 50-50? Or what kind of statistics do we have so we know how many people are actually being incentivized?
David, let me jump in here only because, again, in reviewing what we had done in 2019 and 2020, as of January of 2020, when this was being discussed in the legislature, DOC was able to tell us that 60% of their current inmates at the time had not had a major infraction, which was the terminology on their record within their entire sentence of 1 to 3 years. So we were looking at the average sentence length in Vermont, which is 1 to 3 years. 60% of people who had that sentence length had not experienced any major infractions. But that's, 6-year-old information. So I would say DOC would probably be able to pull that for you to some degree and tell you what that really means from a population standpoint today.
Thank you.
So Alan, I'll transition to you and weigh in here on terms of the Vermont structure.
Yeah, sure. So like you said, Representative Emmons, when we were working on Justice Reinvestment 2 6 years ago, earned good time already existed in Vermont. And at that time, people were able to earn 5 days off of every 30 that they did not achieve or not achieve that they did not have a major infraction on their incarceration record. So if someone was meeting all of the marks in their behavior for 30 days, then they were able to earn 5 days off of their sentence. And as we were talking with legislators and with DOC leadership at the time, the recommendation that we made was to increase that to 7 days for every good 30. And really important here to what David was saying, to decouple the calculation of earned good time from participation in programming, and instead to make the participation in programming a release decision. So I'll explain that a little bit. What we understood from DOC staff and leaders was that it was very, very difficult to calculate earned good time based on people's participation in programming, partly because people's participation often gets interrupted as they are moved between facilities. So because Vermont has no jails, because Vermont has an overcrowding situation in the sense that there are more people incarcerated than prisons can hold, and on any given day, someone's going to be booked into a prison when they are pre-trial instead of a jail, because we don't have a jail system here. It means that there's a lot of movement, at least as of 2020. There was a lot of movement in the inmate population between facilities based on where there's space for everybody. And that would lead to a lot of interruption in programming. And also, I think crucially, a disconnection in the communication of people's participation in programming to keep up with the calculation of their earned good time. So what we were hearing is that it was just very, very hard logistically to count the days with the programming requirement built into that. And instead, what we recommended and what went through in the Justice Reinvestment 2 bill that was passed in 2020 was that participation in programming should be a major consideration when a person is up for parole or when they're considered for release on furlough. But that to get to that moment in time when the decision is made, in order to earn time off, don't consider the consideration in program or the participation in programming, make it about major infractions. I don't know if that's coming through clearly, and I'm happy to send this in writing too, because I really had to refamiliarize myself with this early this week. But and it also might not be the situation for DOC today. It might be much easier for them based on a number of different systems and changes to really keep very consistent track. But what they were saying is that that's going to make it very hard to keep track of the right count on days off. So instead, the parole board and DOC in making furlough release decisions should absolutely be considering if a person has participated in the programming that's been recommended for them. And if a person hasn't and they feel like that person's not ready because of that, then that person would not receive parole or get out on furlough. But to get to the moment in time when that decision is made by way of earning time off of their sentence, to make that about institutional behavior. So those were two big changes that went through in the Justice Reinvestment. That was the increasing the number of days from 5 to 7 days for every good 30, and then a separation for a logistical consideration from the programming participation. Like I said, I've referenced this memo that we had put together, which I'm happy to share, by the way, if anyone would like to see it, but it's slightly outdated because it is from 2020. But it did remind me about how we arrived at that 7-day point, which is that it felt like it was around the middle of the pack, frankly. There are some places where people could earn up to a third of their sentence off, or a day for a day in certain states. And in the federal system, it's 10 days for every good 30. And so increasing from 5 to 7 in Vermont felt like a meaningful way of addressing some of the issues around the prison population being larger than the facilities can hold, without necessarily doubling or significantly increasing that time off. I'll stop there and see if there are questions or anything else that I can provide by way of context.
With the earned time, is it all or nothing, or do you sometimes only get 3 days instead of the 5 or the 7?
Oh, that's a great question.
It's
I'll tell
all
you what
or
I think. I think it's all or nothing. That's what I was going to say.
Because if you have a
Yeah.
DR in that month, you lose those days.
Yeah, it's like you
For
lose
that
the
month.
month. Yeah.
It's instant reward or instant
Loss of
ramifications
reward.
for your behavior.
So if you offend on day 3, you've got this incentive to just say screw it for the rest of the month.
Or it doesn't matter.
That's what I'm saying. I think
That's-
Right.
Yeah.
The incentive is not to behave if you lose one.
You just said it nice.
The one thing I'll say that I don't know, and this is a great question for DOC, is to that issue, if it's, May 3rd and I have a major infraction, does that mean I have to wait until June 1st?
Right.
Or does the month start over on May 4th, right? Do the next 30 days count? Do you know, Representative? I don't know that.
Well, you get into their calculation of 30 days, which is different than calendar days. And
Right.
it's a really convoluted way that they calculate. And I forgot what the terminology is, but we went through this when we were doing the earned time, and it's really convoluted. So it doesn't go through your calendar days, it goes through a 30-day block, whatever that is for that. And there's also, they did implement some rules in terms of how earned time is carried out as well. So there are rules in place as well within their policy and directives and administrative rules for that. Joe.
Are you familiar with any jurisdictions whereby individuals who have just been in and out of correctional facilities multiple times are at some point in time barred from the ability to gather earned time? Like you've been here 5 times, you just don't get it. No earned time for you. Is that a thing anywhere?
I don't know, David. I'm not sure if you do, because every state does, as you can imagine, has a lot of specific, in cases, caveats, right? Which that would be one of them, sort of different categories of offenses or criminal history that might exclude a person from a certain amount. I can look into that, but I can't say for sure that is where that might be true.
Fair enough.
Correct.
Were you getting at the bill itself? Because I was just gonna articulate.
That nips at the bill a little bit.
So to just kind of springboard off of Joe's question, so the bill that we're contemplating, H-252, it's right there in the title, an act relating to prohibiting earned time for second or subsequent felony convictions. Prohibiting earned time for second or subsequent felony convictions. Do you have any sort of intuitive reaction to that sort of legislation? Like, yeah, either one of you. Based on, data you've collected.
So, David, I'm curious. I think it will significantly, my guess, and I don't know if there's been any analysis of this. We certainly haven't done it. I would guess it would significantly increase the prison population. I also think if earned good time is meant to be a tool to incentivize good institutional behavior, first and foremost. And as David pointed out, that's for security reasons. That's also for, it's not just about avoiding major infractions. It's also trying to use the time that you were incarcerated to your own benefit. And all of that has been shown to be very net positive. And so I think removing that, at least for large swaths of the population based on criminal history, could really undermine those goals or those objectives of earned good time. David, I don't know what you would say.
No, I would agree. I also think there's a big difference between whether you're talking about a second time or a third time or a fourth time, right? Or somebody mentioned 5 times. And so if you go from 1 to 2, you're going to increase your population dramatically. If you go from 1 to 3 or 4, it's going to be less so if you're thinking of going down that route. I am not aware of states that have that kind of breakdown. I'm looking right now at NCSL list of states with good time, seeing if I can find anything there. And so far, I've been unable to find that. I'm going to print this out or save this, and I will forward it to Representative Emmons for you all to be able to take a look at as well. And I'll also include the link to the website. What is interesting is that some states, such as Texas, and I actually was not aware of this myself. I have to say I've not done a lot of work in Texas, but some states in Texas actually allow rather high numbers of good time days for certain types of offenses, like up to 30. And so it's interesting to look at the variation around the country. You are not anywhere near the highest number of days. Just to be very clear, as Ellen said, you're sort of in the middle. And some states use something called credits, which makes it even more confusing. But I will send this information to you so that you can take a look at it directly.
Well,
So David, I think you already answered what I was gonna try to articulate, which is that some states do stratify earned time by certain criminal offenses, correct? Maybe not by the number of offenses they've.
Not by the number,
accumulated.
but by the type. And so some lower offenses get much higher amounts of days. Like 20 days or 30 days. And then other states, it's the same for everybody. Although there are also states that say there's certain people they won't let have it at all.
And
You
that's
see
us.
that with sex offenders sometimes.
It's already
Yeah,
carved
yeah, we
out.
have those crimes that are exempt from
Yeah.
it. So I guess,
Carved
yeah, we do have that two-tier system with that. I guess my other thing would be, David, is anecdotally, potentially, if you've spoken to people in Texas or wherever else you've been, primarily doing your research and work with, now I'm blanking on how I want to say this. About whether or not that system is more time consumptive or resource, they're putting a lot of resources towards that process where it is broken down and it maybe is more complex. Like, is it much more of a challenge for them?
For DOC.
Yeah, for those respective DOCs. I'm just curious,
That's really
like,
hard.
if we were to try to replicate another system where it is, more, about the crime that was committed, how, trying to make sure I frame this right.
How complex is that?
Yeah,
Really, the complexity what I would say is that the issue would be how good is the data system, right? If the data system is good and is capturing things accurately, then it's not going to be a dramatically large problem to do that. If the data system is poor, and to be honest, most correctional data systems are poor, then it's going to be very challenging to be able to measure that accurately. And it's going to take a lot of pen and paper work, which is going to take up a tremendous amount of time, of staff time, in order to do that. So it depends on the data system more than really anything else.
Questions? Has this been helpful for folks to understand sort of our system? So detainees do not earn earn time. You have to be sentenced. There is carve out for some crimes that we did. We have 7 days. It can be taken away for that 30-day block, depending on a person's behavior. And you heard testimony, it really helps in terms of the functioning of day-to-day corrections, provides safety for folks who are incarcerated and safety for the facility as well as security for the facility. And also it provides incentives to folks who are incarcerated because losing some days off their sentence is an incentive for folks to behave. It's up to them to make those decisions, a personal responsibility for them to make those decisions. If they're going to behave or not. Sean.
So, Ellen, I don't know if you have heard anything here in Vermont, but has there been any any data collected on the victims, right? That they've seen a shortened sentence for somebody. How are they taking this? And do you have anything to share about that?
Yeah, I mean, in Vermont, when we talked about this, and something that is laid out in statute, but there was a lot of conversation that came before it, was notification, right? Really making sure that is well explained. And actually, I would say outside of Vermont, sentencing and how much time a person will be incarcerated is incredibly important for victims of crime, I think, generally to know and to feel like they won't be surprised. And so in different places, it can get incredibly complicated and hard to predict. And so we've certainly worked with victim advocates and with state legislatures and other places to try to improve their notification systems, but also to figure out how you could provide more information at sentencing or early on so that victims understand, and have expectations, because you hear one number, and then to find out that the number has changed over time depending on that person's experience in prison can be quite jarring. So that is the conversation that we did have in Vermont, was making sure, we worked primarily with the network around that conversation as well, and to make sure that the notification was a priority, right? That the notification system and that the process for letting folks know was really smooth and predictable. But like I said, in some places where the sentencing process and the calculations are incredibly complex, we've tried to work on building tools at sentencing that would give everybody more understanding of what this might be, right? Without predicting the exact number, kind of what could you expect. And just to say, I mean, based on our analysis 6 years ago of Vermonters and their average sentence lengths, our prediction was that, and the number of people who were demonstrating that they did not have major infractions while they were incarcerated, we were showing in our data analysis that would mean around a 20% reduction in their sentence, right? So even something approximate like that is better than nothing, is in my experience of talking to folks about this. But it's not a perfect system. And I don't know exactly how that's been implemented in Vermont. I think that's a great question for DOC and for victims of crime and victim advocates, kind of what has felt, again, kind of well communicated and to some extent predictable, or what has felt surprising, which is not good for anyone.
We've noticed that because we're struggling a little bit with our notification system. So, that's something that we're working on.
Well, we do have a carve out for earned time where we were very clear in the statute that the victim would determine if they want to be notified on a regular basis. If the offender has earned time. It is up to the victim to make that decision, because the testimony that we receive, for some victims, they don't want to know because they feel re-victimized. For other victims, yes, they do want to know. So that's up to the victim to make that determination. Also, when a person is sentenced, it is up to the victim advocate as well as the state's attorneys, and within the courts to let the victim know that the person would potentially qualify for earned time while they're incarcerated for their sentence. So we're very clear about that as well. Kevin.
I'm understanding that our IT systems are poor, and therefore the calculation is difficult. But I would think, and I guess the question I have is, I'm trying to make sure I understand the math. If someone's sentenced to 5 years, is it not reasonable to say if they're good for the 5 years, they're going to get X number of weeks off right at sentencing? I mean, assuming that they're they're good for the 5 years, they're going to get this sentence reduced by a certain amount. So we ought to be able to tell the victims immediately they could get out as early as there.
They could, but
That's
they're
right.
human beings.
I understand,
So
but that's the worst case scenario. They would know that there's possible that they're going to be out in 3 years instead of 5 years.
Well, yeah, but
They do know.
Well, is that the way the math works, or am I missing the math?
No, and you're exactly and there are places where that information is provided. Not like a predict, this is when this person will be released, but this is the range of time that this person may spend. This is their sentence, and then that's how many months they are. If they follow all the rules for earning their good time off, they would reduce their sentence by this much. And so they might get out as soon as here, but they also might spend every minute that, they're sentenced. And that's true.
there's another calculation that goes into that too, their final sentence. If they were detained for a couple of years and their sentence was 5 years, they get credit for time served. So they already have served 2 years of that 5 years as detainees, and that gets calculated towards that 5 years. So then they would have 3 years left.
Right.
Yep.
That's not earned time.
Right.
That's not earned
And
time.
the victim may not be aware of how much time they were held before they were sentenced.
Who knows?
Yeah.
I mean, everybody's a human being, so there's different interpretations and understanding. And human beings can fail. They may not act perfect and may not behave perfect as well. But also when you're calculating a sentence, it is very, very difficult to calculate a sentence. Because there's so many factors that play into it. Well,
Yeah, I had this question, I think last time, and it didn't really get answered. But have you guys seen any data with how the judiciary in whatever state we're discussing, maybe it hasn't happened anywhere, but where the sentencing does increase to account for that? Because that was my, you know,
I don't know if we've ever studied that ourselves, but I will say in my experience, I have heard from practitioners in different states that say what David had mentioned earlier, which is that there's sort of uh, an adjustment on the part of whether it's prosecuting attorneys, whether it's sentencing judges, whoever, to kind of account for good time, right? To say like, all right, well now, if I know that a person could get 3 months off of their sentence, then maybe I'll just factor into my initial plea offer, or what have you, an extra few months on that because I sort of assume that that might come off. But like David said, it's not, I wouldn't presume that that's a universal practice at all. And we've not yet done a project that specifically looked at that, right? To study whether or not there were sentencing length changes in response to good time, or even, in correlation to good time changes. But I've certainly heard it in places, whether it's good time or sentence changes, if sentencing gets shortened or lengths are changed in legislation, you definitely hear from people that there is, like I said, an adjustment by different actors in the system to try to get the sentence that they feel like is appropriate. So I think that's sort of inevitable in some places.
I mean, when we get to committee discussion, I got some comments, but I don't have any questions this
you
time.
can make the comments now.
Oh, well, just to somewhat mirror comments I made when Kevin presented his floor amendment. I mean, I understand the concept of earned time, and I think that it's generally is a beneficial application, although I do think, and there could be discussion, but at a certain point, when an individual just doesn't get it, and this is defined by repeat trips to a facility that aside from the exemptions for certain crimes, that there should be an exemption from earned time just for multiple repeat offenders. And there should be some discussion in that regard. But it's not only a question for these folks, because it's not that I don't understand the concept.
Questions? So has this been helpful for folks to lay the groundwork?
Yeah,
it's
it's a good-
Thinking behind earned time and what it's all about?
If
So
I may,
Dave?
Representative,
Yeah.
I just wanted to offer one thought, which is I gave you all a lot of history about why the Justice Reinvestment proposal and legislation decoupled programmatic participation from earned good time counting. But I would be curious, and I would ask DOC if it's possible to recouple them, I guess, right? To make it a thing where it's not just the absence of major infractions, but it's also active participation in the DOC recommended programming that allows a person to earn time. Or if there's concern around people with repeat offenses, which in many cases, I think, to paint with a broad brush, are folks who most especially need a lot of programming, right? If there's some kind of additional consideration that goes into that, because in 2020 that was very hard to calculate, but that might not be true in 2026.
So the issues we had around all of that was programming is not available system-wide in all the facilities. And for some of the folks, programming is more effective if it's towards the end of their sentence. So there's a real disparity there. Work programs, there's not much work available in all the facilities, and a lot of folks may want to have, be in a work program so that they could have earned time, but the work isn't available to them. Educational programs, we tried to set that up in the past. That's not available system-wide either, so it depends in a way what facility they're in. It depends what is available at that facility. We just took a tour of one of the facilities.
Mhm.
Very limited opportunities for folks to work. I mean, they can work in the laundry, they can work in the kitchen. You know, they can work in the license plate shop, but there isn't a real work program. At one facility, there's no work program except the cafeteria, cooking a meal. So there was some real disparities there. And also it was very subjective because you could have a correctional officer that was maybe out to get an inmate, which is sometimes happens. And it would be up to that correctional officer to document that the person has participated in these programs or education, because somebody has to document that. And if somebody in the facility has a grudge towards an inmate, it won't get filed. And that's what was happening. It was very subjective. And when this one was put in, where you had a major DR, that's not subjective. That's very clear that there was something bad that happened and a disciplinary report was filed and acted on. So we wanted it to be very objective. We didn't want to go down the path again of it being subjective, depending on who was supervising the person and what facility they were at. And the more that you add layers to this, the more cumbersome it becomes for the administration of the program within DOC and central office. Because it's very, very complicated to calculate earned time for 1,200 people, say, or 1,000 people on a monthly basis. So we wanted that to be very clear and concise as well, so we could cut down on DOC staff time. So there was a lot of moving pieces in the past that we tried to correct with this.
Yep, makes
So
sense.
just to put all that on the table. Anything else for folks? So again, David and Alan, I want to thank you for taking some time out. I know this came out of left field for you folks. But I really appreciate you taking some time out of your days.
You're quite welcome.
Yeah, anytime. Happy to join. Thank you so much.
Okay, thank you.
Thank you.
Thanks very much.
Thank you.
Take care, everybody.
Yes. Okay, did we hear anything from Dale? Are they available?
They are, I think they're still in judiciary at the moment.
They're still on
Should be.
judiciary.
And over.
Are they finished there, do you think?
That's what I'm asking.
Okay. Let's just hold on, because I know Katie. Do we have Katie here? You're not Katie? Okay. Because she's due to come in at 2:30.
Okay.
No, Katie McClellan, I was thinking Kelly.
Yeah, it's okay.
You're Kelly, that's what I was thinking, you're right. I was looking at the wrong time frame. For folks who really want to know more about earned time, there is in their rules and procedures, there's the went through the Administrative Procedures Act, there's a full earned time rule that they have within their directives. In terms of how it's carried out.
I'm surprised at the variation of how much earned time per month there. Sounds like there is.
What, in the state?
Yeah, between the states.
Oh, between them.
Yeah, between.
And we took a very conservative position. Took a very conservative position.
Yeah. I'm surprised at that. Everything else.
Also, you have to remember, folks who are in work camp, they get day for day. We did not change it. That's been in place since the early 90s. We get day for day. If they're in the working. That was the goal of work camp. Because you're really-
Which we like.
Yes.
Yeah, you didn't see the work. That's insane too.
No,
We
no.
can't figure out how to give credit for taking it.
Do those guys get, out of curiosity, do they get time for the license plate shop?
No, it's a different structure. They go out in the community. They go out in the
Okay.
community and they do projects for nonprofits and municipalities. And it's more your low risk offenders that we don't house very often now. But this was back in the 90s when a lot of these folks were incarcerated. So it was a way of working through the system real quick
Get them out.
and get them out.
Yeah.
So they would go out, they could be painting, like childcare center.
Mowing cemeteries.
That was something different.
Oh, that's different too.
work
Oh,
crew.
okay.
That was work crew. That was for folks who were not incarcerated.
Right, that's before.
Work camp
Gotcha.
or incarceration.
Gotcha.
That's totally different.
And half the population doesn't even qualify, right, because they're detainees.
Well, half the population doesn't qualify because they're not oldest offenders, even for their sentence. And it's supposed to be for those short sentences, like if you have a sentence of 3 years, you can do it a year and a half if you're. But it's for specific low risk, moderate risk.
The general prison's not working, but
It's in St. James.
yeah, no, I meant half of the correctional facility
Yeah,
population
you
because.
can't do it because they're detainees.
He's still testifying, though. They're not sure how.
Not sure how long. Okay, and Katie's not due in until 2:30.
Yep.
Right.
Kelly, do you wanna bump up and come in now? Sure. I mean, we've got time, you're scheduled for 3:30. You gonna do that now?
Do that if you want to take a break or whatever.
It'll be a half-hour break. Because we're not scheduled for someone until 2:30 and you're here. Yeah.
Okay.
Yeah, he's gonna go down.
Thank you.
So Kelly, why don't you come on up? Sit in the hot seat in the middle there. And it's good that maybe you came early. This
I came early because I really wanted to hear what Dr. Bowen was gonna say. Isn't she Dale? Isn't she up
Yes.
next?
Yeah, well, she's gonna be hopefully.
Yeah, but that's okay.
She's in the other committee testifying. Judiciary. So just tell them that we're taking it
Yeah.
somewhat, we're bumping up somewhat right now. So welcome, Kelly. I know you've sent us quite a few emails and thank you for taking the trip up from Bennington. Appreciate this.
Well, thank you.
If you could just identify yourself for the record.
I will. My name is Kelly Carroll. And first I want to thank the chair and all of the members of the committee for their time and the opportunity to testify. This is a very complex bill, and it is about a narrow, high-risk group and a gap that Vermont has not solved. And I appreciate the time that the committee has and will continue to spend on S191. As I said, my name is Kelly Carroll. I am the mother of Emily Hammond, who was murdered in 2021. And I just want to let you all know, I have watched every hour of testimony on S193 in the Senate and in the House by everyone who has testified. And the other day, and I think it was in this committee, the Defender General of our state called victims irrelevant. And last week in House Judiciary, the Director of Legal Aid that testifies all the time called victims in these cases irrelevant and lacking the experience and the knowledge to understand the complexity of the liberty issues that are at the basis of this bill. And I have to tell you, I find that deeply offensive. And I want to respectfully disagree, because in murder cases, victims and survivors know very well what it means to have liberty taken away. We live every day with the permanent loss imposed by these crimes. We may not all be lawyers, but we understand consequences. We bring the real world result of the consequences of the bills that you pass and the bills that you ignore. And if bringing the real world result and reminding this body of these consequences, if that's what defines irrelevant, let me just go right on the record as saying I am proud to be irrelevant and to be a voice for some of the victims who no longer have a voice, as well as the families who are afraid to come forward because of sometimes the way that victims are treated. So because of this, this is not theoretical to me. And right now, Vermont's system feels like a ping pong match, back and forth within the legislature between the Department of Mental Health, the Department of Corrections, Dale, all the different committees on both sides. And it's very, very stressful. And I guess one question that I have as we go back and forth with, DMH, first of all, has absolutely zero public safety regulations, and that probably needs to change, right? Everybody agrees except for DMH. DOC, a lot of people do not think they're capable of handling this population. And then you've got Dale, who thinks that, according to testimony last week in House Judiciary, one of the advocates for disability rights wants people out in secure gated communities, kind of like retirement communities that you put in. And I don't really think that's realistic. But anyway, I guess one question I would have is, with all of this, it really does seem like it's a major case of passing the buck. It really does. And I guess I don't understand why Secretary Samuelson is not brought in. I mean, AHS, right? DOC, Dale, DMH, they're all under that AHS umbrella. We're expected to all work together. I don't think it's an unreasonable expectation to have them collaborate on this. But right now, there's no clear ownership, there's no clear path forward, and there's no real system. And that's the problem. This is a very complex topic. And because Vermont has let this go so long, you've created this gap. And now you're asking, where do we put this small population of dangerous people? Accountability should not be a four-letter word in this body. This is not about punishment. I hear that all the time. It's always about punishment. Nobody's asking for the death penalty. We're just asking you to provide treatment, monitoring, programming, and supervision so nobody else gets hurt. Currently, Vermont is providing nothing. And also, victims should have a right to have our voices heard, and we don't, except for this, and I appreciate this very much. But let me ask you directly. If someone is charged with a violent crime, facing a life sentence, found not competent by a court, refusing treatment, and still dangerous, what's the plan?
That's what we're trying to figure out.
Because right now there isn't one. So I want to be clear. I fully expect Darren Pronto will be released unsupervised to the community once again. I fully expect him to recommit. And so does his attorney, who has testified in court, quote, he needs to remain hospitalized to prevent him from getting into any more trouble, unquote. So think about that. He's already been arrested, detained for attempted murder, released, arrested, detained for murder, and now we have nowhere to put him. So he's going to get re-released and somebody's going to have to monitor that. And right now we have nobody. I told you I've listened to every hour of testimony, and there's been a lot of questions that have come out of all the committees. So I thought it would be nice to do what I call the timeline of inaction, because this is not new. Many of you have mentioned it, and for several of you, it's deja vu again. In 1991, Elizabeth Teague was found not competent and has spent 35 years in custody in a community group home refusing treatment. She started at Brattleboro Retreat. She got moved over to Middlesex. I don't know, Middlesex is closed, so I don't know if she's at River Valley or if she is in a community group home. But it's been 35 years. Now, Jack McCullough is going to testify. He's been with Legal Aid for 30 years. He often says, when it talks about forensic facilities, build it and they will come. And I have news for you. They're already here, and they've been here, and we're developing them. He also says that no one who's competent would agree to have their competency restored just to go to jail. And I think when you look at the amount of time, that 30 years that he spent in there, the 35 years that Elizabeth Teague has spent, detained in a group home, I think you have to look at where some of the problems are. And I just think that that cycle, and quite frankly, with all of the offenders, you have to ask, did you do the right thing by Elizabeth leaving her there for 35 years? Just kind of forgotten. Okay? In 2010, Kathleen Smith was murdered in Burlington. There was 9 years of manipulation and malingering before her killer died in the hospital. He knew how to play the system. He went through different lawyers trying to do it. He died in the hospital. They never got resolution. Her sister, Joanne Kortendik, has been advocating for years for competency restoration. And 15 years later, there still isn't anything. And just to put that into a time frame, coincidentally, a couple of weeks before Kathleen was murdered, a couple of weeks after, Senator Phil Baruth was elected for the very first time. So 15 years, he's retiring, and no change at all in this law for competency restoration. In 2010, a case later known as, I apologize if I do not pronounce this right, but Kulagowski versus Brattleboro Retreat arose from a community-based situation in which a father was seriously injured after his son was discharged. The family filed suit against the Brattleboro Retreat and the Northeast Kingdom Human Services, alleging improper discharge and a failure to warn caregivers about the individual's level of dangerousness before community release. In 2012, Hurricane Irene closed Waterbury. Vermont begins decentralized mental health care and community-only care for Dale. In 2015, the Vermont Supreme Court rules that the state cannot request their own competency evaluation because the statute only specifically stated that the state could request that when it's a not guilty by reason of insanity, but not competency restoration or for competency.
Would you repeat that?
In 2015, there was a case that went before the Vermont Supreme Court. Someone had sued because they were found not competent and the state had requested their own competency evaluation. And they sued because at the time, the statute had said that the state could request their own competency evaluation and not guilty by reason of insanity, but it did not specifically mention competency. So the Vermont State Supreme Court said, you cannot do that anymore. And that was the big reason between Act 57 and S3 in 2021. Did that answer your question?
I think so.
In 2017, the Vermont Supreme Court ruled that the portions of the case in Kulagowski versus Brattleboro Retreat had merit and should proceed, recognizing an expanded duty to warn by mental health providers when a patient may pose a danger if not properly managed. In 2017, later that same year, the Vermont House passed legislation to overturn the implications of the Kulagowski decision, effectively limiting that duty to warn. In 2018, Darren Pronto had his first competency evaluation, which was not submitted. That was for the attempted murder. A second competency evaluation was ordered and he was found not competent at that time because of that 2015 decision. The state could not question or contest because remember, competency is a court determination. It is not a medical evaluation decision. In 2020, S-183, an act relating to a competency and insanity as a defense, passed the Senate, but it stalled in the House. And in full transparency, that was right around the time of COVID, so that could have had more to do with COVID. In 2020, Averill Bellevue murdered her boyfriend, Cameron Fallon. COVID had just hit. The court shut down. She was quickly determined to be not competent remotely and no evaluations or changes in 6 years. In 2020, Darren Pronto was released by Department of Mental Health. He creates multiple violent and threatening acts against several neighbors, and he makes this I am a murder video. And I encourage you to bring Jared Bianchi in and ask him because he has shown that video in Senate and House judiciaries. And it's basically a video where he admits that he can be a murderer. He is laughing at everyone who makes the laws. The state of Vermont can't do anything because he has his competency and he can kill anyone he wants. And 7 weeks later, my daughter was dead. That was 2021. He murdered my Emily. And in 2021, James Perry also murdered his daughter when she went to do a welfare check on him. In 2021, S3 Act 57, an act relating to competency to stand trial and insanity as a defense, had competency restoration removed, but it did include a provision for the right for the state to request their own competency evaluation, and that was passed. So that was in response to that 2015. At that time, Mr. Valerio had raised concerns about the volume of competency evaluations. And that wasn't fully discussed when he comes in and he does his testimonies, but his office indicated that they would request competency evaluations in a broad range of cases, and they would bog down the system, and that is exactly what happened. And Karen Barber-Golnick can validate that if you want to ask her about it. And that decision appears to have contributed to delays and additional cost to taxpayers. And again, DMH Legal Aid, the Defenders General's Office, State's Attorney Dale, they can provide you more detail on those costs because they're not available to somebody like me. In 2022, Denroy Desant commits a double homicide. When he was arrested, the arresting officer asked him what he should be charged with. And he answered him vigilantism. It's right on the body camera. So his defense team requested a competency evaluation. He was found competent. They requested a second one. He was found competent. They requested a third one. He was found competent to stand trial. That process took about 3 years. In 2023, Zanir Mavish Jama, and I apologize for my pronunciation, murdered her shelter manager, Leah. She's later found not competent. That case is still pending. That was in Brattleboro. In 2023, also S89, an act relating to a forensic facility, and S91, an act relating to competency evaluation, were both passed by the Vermont Senate. S91 was the competency restoration stalled out in the House, but S989, which some of you may remember, included a 9-bed forensic facility at the Berlin Psych Hospital, and that made it through the House, most of it. But during the end testimony in Human Services, Dale had testified, and these are their words, that they had dropped the ball on the legislation, and because of that, Human Services had decided to delay the forensic facility for individuals with disabilities, but not mental health. So S89 would go forward for mental health. In 2023, the Middlesex Therapeutic Center is closed and replaced with River Valley Therapeutic Center in Essex. In 2023, James Eaton shoots 3 male college students in Burlington and competency is questioned. In 2024, S192, an act relating to civil commitment procedures and a secure residential facility, as well as a psych-related residential facility for youth, was introduced. However, the forensic facility was removed entirely at the 11th hour by House Human Services. And in compromise for that, emergency procedures for involuntary medications and restraints at River Valley was enacted. Some of you had questioned Karen Barber-Golnick talking about working on this for 10 years. And the reason for that is because they were trying to get that way back for when they started the design phase for River Valley. And those emergency procedures were not allowed until 2024 when they pulled the forensic facility. And I just want to add a couple things about Darren Pronto, because number one, my main thing is one case should not and cannot define state law. But one case can certainly define the gaps for that law. He was arrested in 2015, and this was all on record. Senator Sears had said this during S21 or S3 in 2021. He was arrested in 2015, released with mental health conditions. He was arrested twice in 2016, released with stricter mental health conditions that time. He didn't really do anything in 17 as far as getting arrested. In 18, he had the home evasion, the attempted murder. In 2020, he was let out. So when we went to court after he was found he was originally found with the murder charge to be not competent. Okay? And I told you S3 gave the state the right to request. Well, part of the reason they were granted that was because when he had his competency evaluation, it was less than an hour and a half. He refused to complete it, and because of that, he was deemed not competent. And I'm sorry, refusing treatment should not get you out of your accountability, especially for murder. But that's what he did. And in 2022, the state and the defense made a plea agreement that we were not part of, and I do not agree with it, but hindsight 2020, I think it was a good thing. Full transparency. They decided to agree that Darren was not competent. The state got their competency evaluation. His competency was fluid. So rather than going to a contested competency hearing, they decided his competency he would be not competent. He was taken from DOC and he was placed in the Berlin Psych Hospital. The agreement at the time between the defense, which I'm sure they'll never agree to again, and the state's attorney was that if he was found competent, if he was going to be released into the community, he would go back to the hold without bail. So right before Thanksgiving, he goes to Berlin's hospital. And on Good Friday, we get a call notifying us, because one of the great things that S3 did was it did put in those notifications that you were talking about. From a victim's perspective, those are priceless. So we did get the notification that he was getting moved. We didn't know why. Personally, I assumed that he hurt somebody, was wrong. When we went to court and they were explaining why, it was because he had learned when somebody was getting him agitated, he had learned how to walk out of the room, go to his room, sit in a corner. He basically learned how to control his temper by putting himself in timeout, and they were going to release him. They couldn't put him at Middlesex because Middlesex doesn't have any emergency procedures, so there was no involuntary medication. There was no restraints if he needed that. So the determination was that he would go back to the community, and now the hold without bail. So since 2023, he has been sitting at Southern State being taken care of in corrections with no treatments. But unlike people who, have treatments or participate, he has been offered to have that evaluation and consistently just refuses to show up. His attorney actually said to the judge at one time, "Well, I'm sorry, Judge, but Mr. Pronto is just not a morning person." So then we started scheduling him in the afternoon, but he still didn't show up. So I think that even though it's a hard question, you have to decide, what are you going to do with people who refuse treatment? People like Elizabeth Teague, who have been in there for 35 years. People like Darren Pronto, who have been in there for 5 years. People like Avril Bellevue, who have been in there for 6 years. What are you going to do when they refuse treatment? And I remember Senator Sears telling me, I was so upset when the forensic facility came out. He said, "You know what, it's a compromise. They needed to do that because they needed to take care of the youth psych." And you can't argue with that, but you do need to do something. In 2025, nothing really happened, in the legislature regarding forensic competency restoration or victims' rights in these cases. But as you were finishing up the first half of the session on May 8th, 2025, Elijah Campagna lured a young woman into a Burlington area group home and murdered her. His caregiver was in the house at the time. And I mentioned that because the other day, during Mr. Valerio's testimony, somebody questioned him and asked him about how soon he would expect a lawsuit. And your answer was instantaneously, of 2 minutes, right? Less than 2 minutes. And I mentioned this because Elijah Campagna was found not competent to stand trial after a violent assault, right? He's deemed dangerous. He's placed in an inappropriate community setting. And if anyone should have the grounds for a lawsuit for wrongful death, it would be the family of Miss Collier. But that lawsuit that 2017 Kulagowski versus Brattleboro Retreat that was enacted, that explicitly overturned that decision, and her family has no rights to any. That is another thing that was taken away from victims in these cases. If you have a medical malpractice, you have, a right. But if you are a victim in a mental health related crime, you have no rights. And I have to tell you, listening to all of this stuff over the last 5 years, I honestly believe if you are a law-abiding Vermonter, the state of Vermont does set you up to be a victim. I mention all of this because in 2025, James Perry was found not guilty by reason of insanity through a plea bargain. Placements considered were a Barrie hotel room, a nursing home, his prior residence, which his family felt was not habitable, or a group home. They really wanted him placed into a forensic facility because of the determined risk for him to possibly reoffend. Okay? And that's very, very difficult for that family because that's their dad and their sister. So imagine the situation that we put them in. We made a plea agreement. We never took them into consideration. I do want to give kudos to the judge up there because he kind of worked outside the system a little bit and he let them come in and make a victim statement, which in cases like ours is absolutely unheard of in Vermont. So that was a good thing. And hopefully that will be precedent setting. A little bit different though, because it is not guilty by reason of insanity. And just to refresh, not competent means you are not competent to stand trial. You have to be found competent to be able to do the not guilty by reason of insanity defense. And I really, really, really hope that the next legislative session starts discussing terminology and we change that to guilty by reason of insanity instead of not guilty. In 2025, Denroy Desant was found competent to stand trial after that third competency evaluation, and he was convicted of a double homicide in November. He did not present a not guilty by reason of insanity defense, and he is supposed to be sentenced later this month. However, last week, his attorneys filed another mental health motion, so the case is pending. They're going back. I don't know if he's going to get sentenced. I don't know, but at some point, you need to start looking at malingering. If somebody is found competent 3 times to stand trial, has a conviction by a jury of their peers, and then is still trying to play that mental health get out of jail free card, there needs to be something in the system that prevents that. He's supposed to go back April 27th. Avril Bellevue, she murdered in 2020. She's supposed to go back April 30th, 6 years. It's time to resolve that. It's time for the Chittenden County State's Attorney to request another competency evaluation and move that case forward or make a change in it. She's just sitting there 6 years. And from what his brother told me, she comes onto camera, she throws a toddler temper tantrum about food, and she was deemed not competent because it was COVID and everything shut down. That family has been struggling for 6 years waiting for answers. Just yesterday or last night, this morning, it was announced that James Eaton in Burlington was found competent to stand trial. We'll have to see if they go with the not guilty by reason of insanity defense. However, he has some of the same attorneys as Denroy Desant. So I would fully expect additional competency evaluations under the competency is fluid, and we'll just keep seeing how many we can request. So basically 2026, here we are. Nothing has changed except the increase in victims. The legislature has created these gaps through a voluntary only community-based system without structure. Our current system is the result of years of piecemeal decisions that began with the closing of the Waterbury State Hospital. You patched it together, and in doing so, you've created a system that encourages escalation. So, like Dr. Frankenstein, you've created something you cannot control. You have empowered escalation of violence, and like Dr. Frankenstein, Vermont's system has created some monsters. And that brings me back to the real life of Darren Pronto, my daughter's killer. He's been refusing competency evaluations. We go back every 3 to 4 months. We get re-traumatized. And the only other option is to walk away. And I refuse to do that. He was released once, I told you that, on that ONH, terrorized a community. The night before he murdered my daughter, there was a violent incident. Our local agency was brought into it. Vermont State Police were brought into it, and nobody committed him. He was left at home with his mother, and the next morning, my daughter was dead. So You've heard that Karen Barber has said these hospitals cannot take these individuals, that they risk losing their licensing. Community placements are not equipped, and yes, that's where they're going. And I'm going to ask you to look at the community failures. And you could probably speak to this. You can speak to this better than I can. Last month, our local agency was fined $483,000+ for improper care. I sat through testimony on Friday, listening to an advocate encourage House Judiciary to put these people in iCare's Mission Care in Bennington. Well, it's only 5 or 6 people, she said. They're not really equipped with that. The other thing that she had suggested was putting safe rooms in every building for staff. And I have to tell you, I really struggle with the fact that we think it's okay for our employees and our associates to be hurt, that we're going to put in a safe room instead of trying to put in policies and procedures that would prevent that in the first place. So that's really something that I find upsetting. And I do think, and Dr. Bowen, I apologize, you and I have talked about this. This is not going to be a surprise to you. I'm very upset with the way the whole Mission Care thing went down with the contracts. I don't even think Representative Donahue knew about that one.
Don't get me started.
You know, they are a for-profit company. There wasn't a single person within the state that went down and investigated any one of their facilities. They had 3 resident deaths in less than a year between the fall of 2024 and the spring of 2025, and one of those was in Vermont. And in all 3, they have said no wrongdoing. And all 3 of these are public knowledge. You can find any of them out on the Department of Mental Health for Connecticut, Massachusetts. I don't know if Vermont has theirs posted yet. But this is the place that the advocates are saying, oh, this is so much better than corrections. I had the daughter of a resident there call me. Her mother was a repeated sexual assault victim as a child. She's had mental health issues all her life. She really struggles. They put her in Mission Care, and Mission Care brought in a criminal justice involved resident. That resident was allowed access to her mother. I don't believe there was any physical contact, but there was a lot of verbal inappropriate behavior, re-traumatization, and really devastating for that lady's mother. And they did take that person out and sent him. I don't know if he went back or he may have just gone to one of their other facilities. But I get a lot of complaints about some of the care there. And some of it I don't want to say on camera, but I think the fact that, you know, we went through that contract, we brought the state, Mary brought the state down. They talked with us, they ignored us. Dr. Bowen was not in place at the time. She was going to start in a couple of weeks, but they went forward with it. And it really, to hear a disability Vermont advocate push for that was very, very frustrating. I knew it was coming, right? I knew when they signed the contract that people that had committed murder that were not competent, whether they were legitimately not competent or successful in malingering, could probably end up there. When they talked about placing James Perry in a nursing home, they were looking at a nursing home up in the Northeast Kingdom. So I will say, if he gets to that point, he goes into a nursing home, we'll at least request not to have him in the one local. But there are ongoing concerns about placement and oversight failures tied to facilities not equipped to handle these. And yet the solution continues to be sending people back to the system. I also want to talk about contractors because I've heard a lot of negative talk about WellPath. And I will be honest, I'm not familiar with them, but I would say don't overlook contractors. Contractors a lot of times are subject matter experts, and they, yes, sometimes are for profit, but they're experts in their fields, and they rely on keeping their clientele, their business, right, their clients. And when you talk about something like WellPath, and get them in here because I'm sure they can talk to it much better than I can, their client is the state. They have participants, their clients, that their patients are the inmates. but their client is the state. And I think that I will wrap it up. I think that what has to happen is that you have to have trust in, I don't know if it's BG, the company, the arm that does the contracts. You have to have trust in that they can put the metrics in there and the penalties. There should be financial penalties if they're not making their quality benchmarks and things like that. And that can all be managed instead of just, writing them off. Corporations that own facilities who are for profit, that's a totally different thing because there's nobody that they're really accountable to other than somebody who maybe comes in and does an unannounced inspection. But you've heard about it, expensive. What about the cost of doing nothing? Vermont has invested millions into agencies, housing, and systems that are not working. And there's one question that this committee has asked of everyone. Should we build a new facility or should we modify what we have? And I would say that what you need to do is you need to build an entire system because the facility alone is not going to solve the problem. Pronto's problem started a good solid 6 years before he killed Emily. And I think, I know this whole irrelevant thing really has me annoyed because I don't think that there are a lot of people up in this town that are paid by state dollars that really care about victims. But I also want you to realize that you've created victims that are sitting in jail. Darren Pronto is a victim. Darren Pronto is a victim because in 2015 and in 16 and 16 and 18 and 19 and 20, he didn't get appropriate care. And for 3 years, he has been sitting in a jail cell without one bit of prevention care, one iota of anything for competency restoration. He has just sat there. Now, we're not trying to lock him up and throw away the key, but your system's doing a pretty good job of that right now. And again, Elizabeth Teague, 30-something years. Anyway, I really appreciate this. I do think that as far as cost goes, I'm not asking for any more money. I'm asking you to consider taking 1% out of DMH, Dale, DOC, and have that money reallocated. I think it's time that Vermont takes a look at the agencies, the services we are not getting. There is not anybody that comes in here other than victims who isn't paid by the state, paid by taxpayer dollars, or looking for more money for their nonprofits. And every year they get more money, and we do a really, really poor job at holding them accountable. And I really hope that what you've done with that 483 and holding UCS accountable is a sign of what's to come with the rest of the agencies around the state. Because it's time that this is not a never-ending, bottomless pocketbook for these people. That some of them are making a lot of money and they are not doing their due diligence with what we have. And I tell you, WellPath or any contractor that you get, you should have those reports coming in. You should have those metrics. Leanne Billings is the mother of one of those double homicide victims, Brian Billings. And I can't imagine how she feels after finding out that there's another mental health motion after going through the whole trial and everything. But she had a very good idea that she and we agree on a lot of things. You could bring her in. She's not sold on the DOC having this. She thinks it should be under DMH. Personally, AHS, it's that umbrella. Have them do it. Have them work collaboratively. Keep people secured. I'm sorry. But anyway, we're just asking for a system. So how many times does someone have to commit murder before the state stops releasing them unsupervised? Civil commitment is not easy in Vermont. And according to Eric Fitzpatrick, there's legislation that's working its way through the session that makes it even more difficult for civil commitment. So the bill isn't perfect, but it's a start. And right now, Vermont's system produces delays, release, and repeat, and additional victims who will carry the consequences. So you have the choice. You can continue to pass the buck, or you can finally fix the gap. So thank you very much for listening to me. I really appreciate the opportunity to be heard. Victims don't often get that. We have most of our rights taken away when it comes to mental health courts. I'm also going to ask to testify for Human Services and Healthcare if it comes in. I don't know if that'll be a possibility, but that is going to be something I'm going to request. And I hope that if other victims reach out, that you will consider them. And I know some of this is out of your scope, but Leanne Billings Gleason has decades of experience working in mental health as a social worker. She's got more initials after her name than I can remember. And what's happened to her has caused her to take a step back a little bit. So she's, but that's her story to share.
Thank you. I appreciate it. And I know that the House Human Services Committee and House Healthcare Committee are. So it'd be good for you to reach out.
I will request.
Are there any questions?
Thank you for coming in.
Thank you. Appreciate
Thank you very
it.
much.
I appreciate your time, and I know I went over and, but there's a lot of history and there were a lot of questions that you had, so.
Thank you.
Thank you.
Thank you.
So we're gonna bring in Dale, Commissioner Bowen. And also we do have Katie McLean scheduled to also go through the current language, go through some language and current statute in different arenas. She has a hard stop at 4, right? So we have to make sure we have enough time for Katie. So Commissioner, welcome.
How are you?
This is your first time in House Corrections and Institutions? Well, welcome. And Dale is the Department of Aging and Independent Living.
Disabilities agents. We should say D-Dale. We should say D-Dale.
Yeah.
The Dale.
It's in, it's all within the Agency of Human Services. As it's a separate department, as is Department of Corrections is a separate department within the Agency of Human Services. There is quite a bit of interest upstairs in the Human Services Committee about the DD population, which is developmentally delayed,
Disabled.
developmentally disabled population, and how they might get swept up into being housed in a correctional facility at some point in time. So there's a lot of concern upstairs on that part of the population. So it'd be good for us to hear from the Commissioner of Dale, and we want to welcome you, and if you could identify yourself.
Hi, I'm Dr. Bowen, Jill Bowen. I am the commissioner for the Department of Disabilities, Aging and Independent Living, Dale, and I have with me.
I'm the principal assistant.
And we don't know you at all.
No.
Welcome back to the building, in a different role.
So I have met some of you, but I haven't met all of you. I am here just under 2 years now. And I have come to you from New York, which you can hear in my accent. And also was in Philly 6 years before that. I'm a psychologist by training. I did spend some of my years working for municipal government, mayors. I've been in the public health system. I did spend 9 years in the forensic psychiatry system. I ran the forensic psychiatry service for Brooklyn, Queens, and Staten Island. And I've done competency evaluation. It's not that everybody's going to say. So I have like on the ground experience. I've been at forensic facilities that were being operated in New York City. So I do have some experience in the space. Most of my career has been working with people in the behavioral health space and intellectual disability space. So I'm very happy to be here in Vermont. I do acknowledge that there is a gap in the forensic system here, and not having a forensic facility is not part of my experience. It has been that there is a forensic facility in most of the places where I have been or have worked. So that is a gap. There is at Dale a part of the Developmental Disability Service that is Act 248. That is the civil commitment for people who meet a narrow criteria, but that is a civil commitment and it doesn't include restorability. So this bill, for Dale, we are aligned with AHS. In addition to being the commissioner of Dale, I'm part of the executive leadership team of the Agency of Human Services. We all work very closely together. It's unique for the Department of Corrections to be part of an Agency of Human Services, but there are things that really work extremely well given the size of the population in prison that requires a whole range of healthcare needs. So our ability to work collaboratively is really important. And with a bill like this, I think that that's a real advantage for us to all be working together and thinking about the best way in which we can close that gap here in Vermont. So I'm happy to answer any questions that you have. I am aware that as a state, we have the responsibility to address the needs and the concerns of individuals, especially those who may be vulnerable, like people who do have a range of challenges, mental health challenges, substance use challenges, and those with developmental disabilities, and any disability, actually. I think this bill would also impact people with other cognitive challenges who fall into that narrow range of having that level of seriousness of the charge pending. People with traumatic brain injuries, people with dementia, et cetera. So, but also balancing that with the needs of the wider community and their safety. So we have that responsibility. I think about that as like a Venn diagram, where sometimes the needs of the individuals and the needs of the community don't overlap, but there are places where it does. And I think that this bill gets to that place where we're both looking at public safety and also what are the needs of the individuals who find themselves in a criminal justice space. Many of these folks are already arrested and in prison, right? Because the charges are such high level charges that this is focusing on. So this really is a narrow population, but happy to answer questions specific to the developmental disabilities or other questions you may have related to the bill.
So in your past work life and working with different forensic facilities in different states, how were they structured? Were they totally under the Department of Corrections, or were they under different departments, or were they under joint departments?
Yeah, so they tended to be under joint departments. So New York City has a forensic psychiatry facility upstate in the Mid-Hudson Psychiatric Facility, and I've been there. It's a perimeter secure, and also on a forensic psychiatry service that was run in Brooklyn. And there was one at Bellevue in Manhattan and one in Brooklyn. Again, we're talking about perimeter security was run by corrections, and then inside the facility was run either by the hospital system or by the Office of Mental Health upstate. So it was a kind of collaborative. Yeah.
So the buildings inside were not operated by DOC, but the perimeter of the facility, outside the facility, the perimeter was under DOC.
And transport and other things. So it was, transport other things. And in the hospital one, corrections was inside. They were inside the facility with the clinical and the treatment teams. Even though it was inside a hospital, it really was a there's a deputy warden. They were
So under whose custody was the person?
That's really interesting. They were under the custody of corrections in the hospital. I think they're under the care of the Office of Mental Health in the upstate one. So there were different models that were at play. Bellevue, more like the one that was in Brooklyn at the time. But the hospital had responsibility for the treatment and the care. And there were some people who were in that setting for the purpose of competency restoration.
So could there be a model here in Vermont that instead of the person having, because the way the structure of the bill is, person's under the custody of the Commissioner of Corrections.
Mhm.
That's it. And we know corrections world is very, very different than therapeutic, restorative world at times. Would there be opportunities that for folks who are not competent or in the process of treatment to restore competency or have been deemed not guilty by reason of insanity, that there's dual custody of that person from not just the Department of Corrections, but Department of Mental Health, Department of Dale, Department of DOC, maybe Department of Health.
Yeah, I mean, theoretically, I suppose anything is possible. I'm not sure that you would get something different from doing that. I think from my perspective, what goes on, because there's also mental health units like at Rikers Island that were clearly corrections run, but it was good work that was going on there. I think it comes down to what is the space actually going to, look like, if it's going to be a therapeutic space, if it's going to be one where people are, because when you talk about like contractor, there's a clinical teams that are there that are providing the healthcare now. So they need to be experts in their field. So I'm not sure that the space itself, I've seen hospitals that look like, I've seen locked facilities that were not prisons. Right. So I'm not sure that that in and of itself, I think what we need to be clear about is what kind of a setting are we talking about? And if it's in a forensic, that might be fine. I'm not having a problem with the idea that it's in a correction setting, especially because it's part of AHS. Now that is not typical, right? But the way in which we all work together, that's why not only am I the commissioner of Dale, but I am a member of the executive leadership team for AHS, and so is the commissioner of corrections, and so is the commissioner of health, and so is that. So we work really closely together. I have to say it's quite the team. This is a place where if something like this was building, we would all be involved in that. So I am comfortable under that kind of a structure where AHS includes correction. Yeah.
I get where you're going. The bill doesn't say that. That's where there's the legislation does not say that it's under the auspices of the Agency of Human Services. It's just under DOC. It's under the custody of the Commissioner of DOC. It's in the Department of DOC.
But the DOC reports to AHS as part of AHS.
Yes. So for the forensic director, should that person answer to the Secretary of the Agency of Human Services? Should that person answer to the Department of Mental Health? And should they answer to 3 commissioners or the secretary? Because right now it's a contract position within DOC through WellPay. So it's kind of a fox guarding a hen house. So that forensic director, should that be under the Secretary of the Agency of Human Services?
So
if everyone is working together.
Here's how I want to answer. Right now, this bill is about closing a gap in the system, right? For people who don't have an opportunity to be restored to competence. If we accept that that's useful, the layers that will come after it, the oversight of the operation needs to be developed for quality and for oversight through like rulemaking. And there needs to be the kind of details you're talking about the specific kind of details about who would this person report to and where's the oversight and all that, I think that's going to come from rulemaking. At this point, we're looking at, is this a gap that needs to be filled? What are the advantages and disadvantages? People have very strong feelings about it. And I think they have very strong feelings about it because we're actually trying to do two things at the same time here. We're trying to ensure that people with disabilities, mental health challenges, et cetera, who are found not competent in this narrow range of having been charged with the most serious charges, but are not convicted of those charges. Whether they can be restored to competence and then can have due process. And some of them do want that. Right? Some of them do want that. Because otherwise what ends up happening is that they never get cleared if in fact they have not committed those crimes. And if they have, then they're not held accountable in the same way. So for developmental disabilities, you're going to find quite a few who won't reach restorability.
Right, so is it up to DOC to provide those services for either DD folks or other folks to see if they could restore competency? Is that a skill that DOC has to do?
I don't think DOC would do that directly. I don't think it's not, but yes, in terms of having the appropriate people come in they have to have the expertise, they have to have the training, they have to be using the proper methods, they have to be, evidence-informed methodology, they have to use tools that are considered reasonable tools by the in the field. For developmental disabilities, you're talking about likely the Slater method, which is one of the few that has some data behind it. If you're looking at violence, risk of recidivism, then there are approaches that, have some efficacy, and there's risk assessments that are understood to have a certain level of validity in the field. Again, evidence-informed processes. So it's not really about, it's what is happening inside that space and making sure that those who are brought in have the expertise, the tools, et cetera, to do this, appropriately. It could be a contractor. Most of the work that is done by AHS is done through contracts or done through designation or done, through rules and statutes or whatever, or not really, like Dale doesn't directly provide a service. The same way I wouldn't expect corrections necessarily to directly provide a service that's outside of their expertise, but what you should be doing is bringing in the right people who are going to provide that. And
the question is, who are those right people? Who do they answer to? That's the question for work.
Yeah, and I guess my interpretation of the bill as written is different from yours. It's not as ambiguous as you suggest. It's incredibly prescriptive, actually. A forensic facility means a locked facility or placement that the Department of Corrections provides for the security evaluation, treatment, and care of persons involved in the legal system who do not require hospitalization or other care. So this very clearly defines DOC as
right. So I'm not
entity.
having a problem with that, though.
Okay, so I do.
Yeah.
Yeah.
Oh, okay.
You had presented it as more ambiguous than that. It's not ambiguous. It's very clear that DOC is.
Okay, I wasn't trying to be ambiguous
Yeah.
about that, and there's a reason for that, right? Because these are broad. The people who would meet these criteria are not any particular diagnosis. They're not any.
I get that.
Okay.
Yeah.
And so what we need is, a path for them to have, regardless of whether some of those folks, if they weren't in prison, would be someone that Dale would be taking care of, or someone that the Department of Mental Health would be working with, et cetera. You need the broad range of ability to have folks come to a place where there'll be competency restoration activity going on, and also assessments of risk.
Right. Okay, and you don't have a problem with DOC providing that?
I don't, as long as the right people are brought in to do it that have the expertise. And I do feel that DOC being under Agency of Human Services,
That's a bigger can of worms for many.
It's bigger
Yeah.
cameras.
Just because.
I
they're
got
there,
my
yeah.
thoughts about that. And if you know, you're not in the room with us when we're doing our thing, but it's very close and we're really all working together as an agency, but I'm just here to answer your questions, not necessarily to get too much into the weeds exactly how it will be operationalized, because I think that's premature right now. The question, I think, is, do we need to fill this gap in the continuum? Yeah.
We all agree we need to build something because there is a gap. The
Agreed.
question is where you physically house some. That's the question. I don't think anyone disagrees. It's a gap. We really need to fill it. Let's fill it appropriately with the appropriate partners there and not use something that's real easy at this point. Because what I hear from folks, and not you, right? So what I hear in the building is, well, they're already in corrections. They're already there. So what's the big deal? That's the reason for why DOC's chosen here. It doesn't mean, maybe we house them in a DOC facility, but facilities aren't very therapeutic or residential like. But maybe we do an adaptation somewhere, but it's who makes those determinations of when the person is competent? Who makes those determinations in terms of what is needed for a person possibly to restore competency? Is it the Commissioner of Corrections that makes all those decisions, which is where the rub is? I think.
Okay, so I'm hearing you, but I also have been in facilities that are very therapeutic inside. It depends on how it's built.
Well, that's it exactly. Our correctional facilities are not built as a residential therapeutic.
Yeah, but I mean, what is developed inside the space that would be identified?
So that's a long-term process, and that no one's talking to us as a committee that deals with construction of state facilities or with the Department of DGS in terms of what would be needed and what's the cost.
Yeah, I get you, but my point is, it's not necessarily what the structure is on the outside, it's what it is, you know,
Well, that's what I'm
who
talking
coming in.
about, layout of the facility inside, where the living units are, where the structure.
Mhm.
So we're gonna move on to what, but I'm gonna go to Mary and come out.
But just as important, it's the people running and doing the facility. You know, we've done this for how many years now? We keep kicking the can down the road. There's no one looking to really look to coordinate. And we all say we're working together. And a lot of the times, there's a lot of missed pieces that create a lot of problems. And I think that's what I'm hearing from this committee, is that we want to do this right for everyone involved. And not, you know, even at the end of the day, if the person is not found competent, do they just rot in prison for the rest of their lives?
Right.
And yet, do we let them out in the you know, outside of the prison when we don't know what their capabilities are? You know, this has become ridiculous, the discussions here. I know everyone's well-intended, but we've got to do this right and finally do it right. And not, you know, it's.
Once a person is determined to be not restorable, that is where that's what's going to happen for about at least half of the people who have developmental or intellectual disability, who meet that. And it's not going to be a lot of people. So we're talking about, I keep going like this because in my mind, I have this very narrow band of who would end up in that situation with a developmental disability, because it's for folks who are charged with, you know, something that would, if they were found guilty, would be a lifelong, right? And most of the folks who, right, people with developmental disabilities are more likely to be victims of crimes, right? So you're going to have very few people with developmental disabilities that are going to end up in that space. Most of them are facing misdemeanors. In most of the places where I have worked, people who have mental health challenges or developmental disabilities who are found not fit with misdemeanors have those dismissed, have those charges dismissed. So when you talk about this particular group of folks, it's really very narrow. And if in fact they can be restored to competence, they may actually want to be restored to competence. And if so, then this gives them a chance to possibly be restored and then go on with their case.
Questions here, James.
Thanks so much for coming in, Commissioner. So I completely agree with you. I think it's a good thing corrections is underneath AHS, as opposed to like public safety like other states. My issue is the contractor, WellPath, and you do a Google, I always say this, and I just did now, it's falsifying medication logs. It's like, it's diverting medicine, it's layoffs, it's bankruptcy. And I just can't see how we look at a company like this and say, you know what, I want more of that, I want to swell this. Nobody's come in and said, this is the best company going. There's good people who work for it, but we use WellPath because they're cheap and they're one of the only ones who do it, So I think I need some reassurance there as far as sort of the group dynamic at AHS. What is Dale's role working with WellPath? Because we have people who, would fall under sort of Dale's purview in corrections now being treated by WellPath. Is there sort of a hands-on approach to Dale coming up with the contract metrics, having oversight while the contract's been implemented, and just making sure they're doing right by the people in there? Because I think that's going to be a big thing going forward for me, that like, why are we increasing this contract and putting in corrections when I don't think they're doing a good job now?
Yeah. So, so we don't, we're not involved directly with the contract, but for the people, do you want to talk about the way in which we are helpful? Yeah.
Yeah, absolutely. So appreciate the question about how we work with the Department of Corrections for individuals who are identified as having a developmental or intellectual disability. So the commissioner is absolutely correct. We don't oversee that particular contract, but we do have individuals with clinical expertise that work directly with us. And so when someone is identified as either already being engaged in our services or potentially needing eligibility, we get outreach from the Department of Corrections asking what records we have, what sort of therapeutic support plans might already be in place for that individual. We provide information so that they can have continuity of care. And then we do engage our Vermont Crisis Intervention Network so that their clinicians can go and provide visits to individuals who are either being held or currently incarcerated, and then meet with the clinicians at the different correctional institutions so they can talk and provide sort of expertise, be available to meet with individuals who are incarcerated. Oftentimes people who are receiving services lose a lot of their natural supports because Medicaid isn't available to be paid for people to visit. So we want to make sure that they do have visitors, and sometimes our team will go and visit as well as the division. So they're getting regular visits, getting some clinical expertise for people who have specialized in developmental or intellectual disabilities, and then can provide that back to the correctional teams experts, because perhaps those clinicians haven't done a lot of work with people.
So that might surprise you. I'm here a little less than 2 years, but that was a high priority for me coming in as commissioner, that the individuals who are in our system are all of ours. And today they might be in prison, but tomorrow they'll be in the community, or today they may be in the hospital, and tomorrow they'll be back with a designated agency. So this kind of collaborative work is essential when people are whole people. And they may be anywhere in our system at any one time. And so this kind of a collaboration makes for good working relationship with our co-departments. We're there for each other. We support each other, and we get in there on the ground when need be. Similarly, when there are folks who are have been, let's say, in prison for that have other disabilities besides developmental disabilities, or are in our system, like our Choices for Care system, if they're an older Vermonter, for example. So we do work very closely. If there were situations that would arise in this kind of a conversation that we're having about competency, we would be having conversations about the individuals and making sure, especially if they're already in our system. So a lot of these folks are already in our developmental disability system and have a support plan in place. And so we want to maintain any progress that's being made. And we're also the Act 248 people. So those are the civil commitment folks who come in, who get committed essentially to the commissioner. And so those folks have had criminal justice, intercepts in their lives already. And sometimes there may be a situation they go back into, they get rearrested. We're there. We go to the court, we listen to see what's happening with the case. We set up a plan for when they really, because some of them are in briefly. And then if there's a longer term situation, then they're going to come back out into either public safety or an Act 248, we want to be ready to receive. So there is more overlap and collaboration for the individuals that we both serve or that we all serve, which is different than managing or setting up the contract. But did want you to see that there is more.
No, I appreciate that. I think like one thing I worry about is it's not explicit in this language that we're reading, right? This collaborative relationship that you seem to have established with the other departments here.
Yeah.
And legislation is ongoing. The relationships can vary from administration to administration. So to have Dale and DMH more in a footnote, in this legislation, and DOC will work with them, that gives me some pause, right? Rather than having a more formal oversight role in the custody of these folks. Right?
I do think that just generally speaking, that whoever goes in to manage them, whether it's WellPath or some other expert group, or it goes up, however, whoever goes in there and is providing it has to be able to provide the competency assessments, the competency restoration, the violence risk assessments, and the interventions that help people to succeed. They have to have the expertise to do that.
Thank you.
James, Troy.
Well, your last point was my first point. So I think there should be, one of the parts that I thought was too vague is that I think there should be more concrete language in this bill tying in DMH and Dale. You already covered that, but my other thing is, like Troy mentioned earlier, he felt like your interpretation of the bill was vague compared to, we think there's certain things that are very concrete. And you said that you didn't think that you meant it that way, and it's fine. But when we were talking to the commissioner of DOC last week about placement and, whether or not it would be a whole new facility, or we're taking an entire wing and you're adding on or changing a wing and having these individuals in their own place, he had told me that he felt like they could stay where they are, intermixed with everybody. And so it seems pretty clear in this bill that that's not the case. But if people's interpretations are these, just kind of when you made the comment about feeling like comments were vague, I'm very concerned that people outside of this building have a different interpretation of what seems clear to us. And so that kind of concerns me. Because the bill says very specific things, and I think at least that they have to be in their own place, not intermixed with the general population. And if it doesn't seem like it's that way, then it should be. Although I'm an advocate of someday having our standalone facility, even if they are in the correctional facilities as it is now, at least being in their own place with a more therapeutic vibe, if you will, but definitely not mixed in. So and I realize you're not that commissioner, but
Right, I'm not that commissioner, but,
but the difference in interpretations is worrying me, put it that way.
well, so I did not mean to be vague. I was trying to compare it to, in response to the question about what was done in New York and some of the other places that I worked. And that's where there are differences in this. Here, it seems clear that it would be in a forensic setting. Not sure what Commissioner Murat had said, but the idea of having the right people come in who have the skills to provide it is I think is if it's not explicit in here, that was my understanding, is that the skills that are required to do competency restoration and competency evaluation and risk assessments, it has to be the right tools that can fit. And whether that's WellPath or not is not that. I don't think that's clear to me right now. Like who exactly would be doing that? And if it was WellPath, and I take your point, are they the ones who have the training? The individual people. So I have worked in settings where there are contractors that come in that provide it in prison settings, and some are very good, but sometimes it's an individual or two or three who have the specific skill to provide a specific thing. And it depends on, their training, their ability to provide that.
Ryan, Mary, and Kevin.
I'm gonna start with a question that risks sounding antagonistic, and I really don't mean it to be antagonistic. It's gonna just help me kind of get some context with a follow-up question. Have you seen the inside of our correctional facilities?
I went to Marble Valley.
Have you been in an individual cell?
I walked into the individual cell.
Okay. I don't know how that compares to, I have
That
not.
wasn't antagonistic.
No, I could,
That's a good
it risks
question.
sounding like,
I
have you
went
been there?
because
Right, I don't want it to
well,
sound like, have you even been there?
I did
That's not
because
where
I
I'm
was
going with
curious.
this.
I
Yeah.
really wanted to see it.
So I don't know how Marble Valley compares to Northwest. I haven't been to Marble Valley. I have been to Northwest. I have been to CRCF as
It's more
well.
confined.
It is.
But the inside of a cell is similar. Yeah. That's my worry. Because and you're not this commissioner, to James's point, when I asked the commissioner if, similar to his questions, do you foresee bringing these people out of general population into a place that feels, by definition, is designed and operated in a manner that supports a therapeutic, recovery-oriented, and trauma-informed environment comparable to community-based residential treatment settings? That's what we're describing by statute. And I asked him, do you foresee needing renovations to get there, to turn our facilities, those cells, into that, a therapeutic, this is therapeutic, recovery-oriented, trauma-informed environment, right? And his answer was no. He doesn't necessarily see needing to make those kinds of accommodations to get our current facilities to meet that definition. I'm in disagreement with that. I think we would. And I want to state this very, very clearly. I know we need this service. I know we need competency restoration so that people who have been charged with these crimes can face due process and possibly ultimately end up incarcerated, right?
Or released.
Or released, certainly, right? I get that. And I know that there are people who have fallen through the cracks that we currently have in place that should not have fallen through those cracks and are landing in our communities and causing harm. I'm well aware, and I know that that is happening. My question to you, I guess, is the same I had to the commissioner. Would you consider that cell that you walked into to be meeting the definition of what this bill describes as a forensic facility?
So I'm going to give you, so of course you don't want anybody in those cells. I mean, I wanted to see them so that I could experience it. I specifically went to look at where a youth might be, right? Because you don't really.
We don't. That's another gap.
So right, and that was concerning to me
Right.
that it wasn't, right, I know I'm working on it. But also I can imagine that someone with a developmental disability might be in that
Right.
cell as well. So
Right.
that, I wanted to see that.
Or dementia, or,
Or someone, okay, so, so just from my experience, I have to be cautious not being there, during like regular operations to see, are they spending a lot of time in there or are they spending a lot of time elsewhere? Because I saw other places too, that where there could be more communal activity and stuff going on. And I looked for it, I wanted to see it, where's outdoor space?
Right.
Where's gym? Where's the, right, and there was, in this case, there was some. So I can't judge it, just can't judge it just by the cell, it really depends on how much time you're spending in there and what other places there are, so, but I do appreciate the question very much.
Mary and then Kevin.
Again, I'm going to say the collaboration is great, but I'm dealing even with a case in Bennington right now that I can't get the commissioner of mental health to respond back. And I've tried, so I've gotten the deputy commissioner who has basically done nothing. It's been a court-ordered type of situation for someone who's assaulting and hurting people, and it's ratcheting up until something is going to happen. And I'm tired at the end of the day for us to say, when something awful happens, we say, oh, how did that happen? What could we have done to prevent it? I understand we were all extremely busy. You are extremely well-intended to have this work right. But, going around where you can't even talk with the commissioner that could help a family that's been assaulted a number of times, won't even talk. You go to call and you says, leave a message on my phone. I've got a direct number and it's always full, so you can't even leave a message. We've got to have connected pieces. And yes, this is a small group of folks, but we are growing the numbers by the lack of what we're doing. We've got to do this right. And I know you're saying the collaboration is there. I'm not always sure because even the Human Services Commissioner, who does, as you said, and we're aware of, oversees all these other adjoining committee or commissioners. There's not always the best of communication there either, or direction to be given. I want people that can really do this and do it well.
I understand that. I understand what you're saying and I appreciate it. I have to say, my experience with my co-commissioners has really been exceptional, extraordinary, and that's not necessarily
But
translating.
that's great. They
Yeah.
can on your levels of commissioners, but they can't with the real world out there. That's the problem.
So, okay. Thank you.
And I'm
Yeah.
sorry that
Yeah,
I'm
no, but
sounding
thank you.
this way.
I hear you.
But I'd be correct in assuming that your team, you as the commissioner and your team, are aware of this 5 or 6 individuals that are currently described by this bill. I'm not asking for names, but
There is a specific department for disability aging living, so it's not under Department of Mental Health. That's something different. It's not under the DOC. They have just a very specific group of folks that they work with. So the question is, do you know of anyone of the 5 that are currently incarcerated, or any of them under your department?
I don't think so right now.
I don't believe
Mhm.
so.
Right, because we usually will get pulled in if it's something of that level.
okay, so then I obviously don't understand what we're talking about. If the teams are working together, I would think that you would have been pulled in by now on all 5 or 6 individuals that would be affected by this bill. So I'm
not
showing
if
my
they're
ignorance.
not a Dale client.
Yeah, come on.
It might be a DMH client, they might, yeah, there could be a.
The bill has the bill, yeah, the bill has is built that there could be a Dale client in the
Right.
at any time that would have allegedly committed a crime of such magnitude that they would qualify and be found not competent, that they would be identified as someone who would go to this unit, right? And then would need to go through a competency restoration period and assessed for whether they are restorable. You know, some of them may be restored through the Slater method, and some of them will not be restorable. Many of them have never reached competency in their lives. So we talk about it as attainable. And if it is for some of them that will be able to be found competent, then they would go ahead and be able to have their due process, right? Some of them will not be restorable, but many of the folks that come in to this won't be with developmental disabilities, right? Because you think of the population in general of folks who have developmental disabilities. They could have some other disability, like I said, TBI, because that would fall, or perhaps Alzheimer's, in which case we would likely have more awareness of specifically who these individuals are. Yeah.
So now I think I understand that you may know of a subset of the thin group. But it sounded to me like your team has the expertise and the desire to do what these individuals need. In the absence of your team being involved, are we back to WellPath providing all that?
No, if it's not, so WellPath would, first of all, if it's WellPath, right? If it's WellPath, so our team would not go in and do the restoration. When I say our team, I'm saying we don't directly provide services in any of our services through contract. It's through designation. It's through licensure and regulation and compliance and quality and all of those things that are required for all of the providers. There's quite a few, of course, the services that we support in Vermont. So, and it is still a separate department than other departments, but the fact that we work together in our collaborative means that we are there when different things arise in our different areas of specialty.
So I want to move this along. So we do have our legal counsel here that does have a hard stop at 4. So we do want to move this along. Any questions here?
If not, thank you.
Thank you for coming.
Thank you very much.
Short notice, you went down the hall.
Yes, yes, thank you. And I appreciate that this is being looked at and the care and concern that you have for the people that we care and concern. Yep.
So I want to keep moving. If you need to take a personal break, take a personal break, not all at once, please. Katie, you want to come on up? This is the first time you've been in this year. One thing I wanted Katie to go through with us is we put in statute over the years, quite a bit over time, about folks who are in a mental health situation one way or another, and end up in corrections. We have current statutes that deal with this. There's also an MOU between DOC and DMH in terms of there's some incarcerated and severely functioning impaired or with mental health issues. Yet over the years ago, there was an MOU, a couple of them were developed between DOC and DMH in terms of the care of the person while they're incarcerated and within a correctional facility. So I asked Eric Fitzpatrick when we had to walk through the best 193 downstairs in the joint meeting, the Judiciary Committee. I asked him, and has anyone looked at current statute? and how proposed forensic facility within a correctional facility would augment our current statute or be in conflict. So I've asked Katie to go over current statute, and she has a document that summarizes this. And some more background as well, and some reports that have been done over the years as well. So there's been a lot of reports.
Yeah, there's a lot of activity for a period of years.
So Katie, welcome.
Thank you.
For yourself for the record.
Sure. Katie McLinn, Office of Legislative Counsel. So I put together, this is, oops, is it sharing? Okay. This is maybe more information than you want, or more words on the page than you want, but even if we don't hit on it all now, it's nice that you sort of have it in front of you. So I have sort of a summary of what is in place in terms of statutes around mental illness.
Did you make the right, did you make the?
Yes. You're not the first person who has asked for that today. Is that a little better? Okay. And then there's also just sort of a summary that we don't have to go through of some of the work that has been done in the past maybe 10 years around SFI. I don't know if the conversation will take us there, but I also have slides about how the process by which somebody who is in need of mental health care, who is coming in through what I kind of call the forensic door, they're coming in through the criminal justice system, what that process looks like currently. So I'm not sure if you want that or if that takes us too far afield. Okay. Okay. So I'm gonna actually skip ahead to the we can come back to this, but the definition of serious functional impairment is halfway down the second page. I have the statutes organized in order of their number, but SFI doesn't appear until 906. So serious functional impairment means disorder of thought, mood, perception, orientation, or memory as diagnosed by a qualified mental health professional, which substantially impairs judgment, behavior, capacity to recognize reality, or ability to meet the ordinary demands of life, and which substantially impairs the ability to function within the correctional setting, or a developmental disability, traumatic brain injury, or other organic brain disorder, or various forms of dementia or other neurological disorders as diagnosed by a qualified mental health professional, which substantially impairs the ability to function in the correctional setting. And I think that last phrase in both of these subdivisions is really the heart of it, that impairs somebody's ability to function in a correctional setting. What this does and doesn't do. Serious functional impairment is not a clinical diagnosis. In fact, there was legislative intent language added a few years to clarify that this is just a correctional designation and it's not a specific diagnosis. These are individuals who may at some point be transferred for care to the Department of Mental Health, but not necessarily. They might not have an acute need for care. This does not, how this is different from the population in the bill you're looking at is somebody who is designated as serious functional impairment could be in a correctional facility for any type of crime that was committed. Whereas, as you know, the bill you're looking at is individuals who have committed very specific crimes.
Just ask a quick question. Are these in Title 13 as well, or just 28? And are they linked for
Because
13?
it's dealing with how DOC classifies the folks, where they place them, segregation. That's what it deals with in the corrections world.
SFI only
Just-
exists in
okay.
a correctional setting.
Okay.
Yeah. Okay, now that we've sort of seen.
Only in a correction?
Mhm.
Well, I learned something.
Yeah.
Not out in the field.
Okay.
Now that we've looked at the definition, maybe I'll bring us back up to the top. So now we know what we mean when we say serious functional impairment. So there's a section in 701A, and this has to do with segregation of inmates with an SFI. So the commissioner is to adopt rules regarding the classification, treatment, and segregation of inmates with an SFI. The length of stay in segregation is not to exceed 15 days if the inmate is segregated for disciplinary reasons, and it shall not exceed 30 days if the segregation is requested by the inmate for some other reason or for some other reason. Successive 30-day periods are allowed with certain processes in place. The department is to submit monthly reports to the Corrections Oversight Committee regarding each inmate in segregation, whether the inmate has that SFI designation, and whether there have been any self-harm or suicide attempts by inmates with SFI.
You might not have it handy, Katie. I'm wondering how this compares to the criteria for admittance to the Vermont Psychiatric Hospital.
Yeah.
I always thought that was like you had to be sort of rejected from every other designated hospital in the state.
Not rejected. I'll pull up the statutory language so you can see it. Hang on. So to be, well, that's involuntary care. Are you talking about involuntary admission?
Yeah.
Okay. Well, that is easy to find. So that's 18 VSA 7101. Let me pull it up.
I don't know how you remember all of this.
I don't remember all of them, but this one I do.
Sorry to pull you away from this, Katie.
No, that's okay. Okay. So here we go. Involuntary admission to the a hospital for psychiatric care. You have to meet this standard, a person in need of treatment. So this is a standard that says you have a clinical need for involuntary treatment. So this is clinical. I know we talk a lot about competency in the judicial sense, but this is in the medical sense that this is a person who needs treatment. So this is a person who has a mental illness, and as a result of the mental illness, his or her capacity to exercise self-control, judgment, or discretion in the conduct of his or her affairs and social relations is so lessened that he or she poses a danger of harm to himself, herself, or to others. A danger of harm to others may be shown by establishing that he or she has inflicted or attempted to inflict bodily harm on another, or by his or her threats or actions, he or she has placed others in reasonable fear of physical harm to themselves, or by his or her actions or inactions, he or she has presented a danger to persons in his or her care. And then this B, a danger of harm to himself or herself may be shown by establishing that he or she has threatened or attempted suicide or serious bodily harm, or he or she has behaved in such a manner as to indicate that he or she is unable, without supervision and the assistance of others, to satisfy his or her need for nourishment, personal or medical care, shelter, or self-protection and safety, so that it is probable that death, substantial physical bodily injury, serious mental deterioration, or serious physical debilitation or disease will ensue unless adequate treatment is afforded. So that is the medical standard. And if there are a few stages before a person can be committed to a psychiatric hospital involuntarily, but that's the standard everybody's using to say, do they meet the medical criteria? And the court finally makes the decision about that commitment process.
So an SFI could meet that criteria?
Possibly,
Yep.
or not.
Or not?
Yeah.
And it's as fluid as competency is, right? They can regain.
Right, but and Katie, I think you're gonna go into this and transfer it to the state prosecutor.
Mhm.
There are folks who, with SFI or serious mental illness, it's not considered maybe SFI.
Mhm.
They reach an acuity in their medical by this definition, reach certain acuity while they're incarcerated. They could be sentenced, they could be a detainee. There's agreements between DMH and DOC that the person can be transferred to the state hospital. to be stabilized. And brought down from that level one acuity. Once a person is stabilized, they will go back to corrections. They will not stay with the custody. That's correct.
And this, again, is involuntary. So potentially there could be somebody who has a serious mental illness. It does not rise to the level of them needing involuntary care. And that person might voluntarily recognize that they are in need of hospital level care and they don't have to meet this medical standard. They could receive medical care for a lower acuity of mental health needs.
What would that be through the state system? Because through the state.
I mean, this
system,
is-
you put under the custody of the commissioner of mental health.
They wouldn't be.
Voluntary.
If they're voluntary, I think if they're voluntary, they're not necessarily under the custody of the commissioner of mental health.
Right, and they wouldn't be accepted to state hospital, would they?
I believe that's a level 1 unit. I don't know if they
Would they
accept
be
just
accepted at
voluntary.
River Valley?
That's
That's
a step down. So that's not hospital level care. But they would still have to meet this standard of being a person in need of treatment.
What if they're incarcerated and voluntarily realize they need hospital level care and they're not convinced that they're getting it from the DOC?
Yeah, I knew somebody was gonna ask that question. I guess that'd be a better question for DOC about what happens in that situation. I'm not clear.
Okay,
Yeah,
thank you.
So let's get back to your
Yeah,
document.
sorry.
okay.
It's like a choose your own adventure book.
So a lot of the mental health statutes, and Katie's gonna go through, are a result of, we started to deinstitutionalize state hospital back in the late 80s. And what was starting to happen through the 90s in particular, and that's only gotten worse, is more mental health folks with mental health issues have been showing up in corrections. And that has only escalated over the years. So that's where a lot of these statutes come from, because there was nothing in Title 28 that dealt with folks who are incarcerated with mental health issues.
So these next two sections deal with a transfer between the departments. Note, I mean, this is a summary, but note that this language doesn't give us any guidance about the question about voluntary or involuntary. So the commissioner is authorized to transfer a person under arrest and charged with an offense. If a person has manifested a mental illness requiring treatment, the commissioner is authorized to initiate a transfer proceeding pursuant to 703. This is 703. When the transfer from DOC to DMH occurs, the individual shall be under the supervision of the Commissioner of Mental Health, except that time shall be computed as part of the individual's sentence.
So, right, so in 702B, this is just dealing with folks who have been charged, they have been sentenced,
Mhm. Yep.
okay?
And they're treated in accordance with 703 for a transfer. And then 704, when the Commissioner of Mental Health determines that the person whose sentence has not expired no longer needs to be under DMH's supervision, the Commissioner of Mental Health shall return the individual to the custody of the Commissioner of Corrections. And in 705, this is what happens if their sentence expires while they're receiving treatment. When CMH determines, CMH, Commissioner of Mental Health, sorry for the shorthand, determines a person requires further treatment after the expiration of the individual's maximum sentence, the commissioner is to petition the criminal division of the Superior Court for recommitment of the inmate to the custody of the Commissioner of Mental Health, which is not inconsistent with our mental health standards or statutes that say for commitment to a mental health hospital, a court is making that determination. Page 2, this is that legislative intent language that was adopted not so many years ago, that it's the intent of the General Assembly that SFI designation applies solely to individuals residing in a correctional facility. and not to individuals reentering the community after incarceration. When gone through this definition, 907.
So can I just clarify that? So upon release, SFI just evaporates.
Yeah, there's a reason for that. Because we tried to put in place some teams that would work with our local DAs to really provide services. And what happens when you get back out in the community, now correct me, Katie. Well, for your local DAs, designated agencies, mental health agencies, the terminology is CRT. Is it CRT is a terminology?
I don't know if that applies to everybody.
But what was happening was that they had an SFI determination that carried out throughout the community, then it interfered with the CRT classification that our designated agencies were working for and could displace some of those folks with SFI folks. So that's why we then cleared up the SFI designation is only to be used while a person is incarcerated.
Okay.
And it does not transfer to the community because the community has a whole different definition of services, youth services. We didn't want to interfere with that. So that's the history. Okay, I'm standing by it. Because we spent a lot of time in this committee and Senate Judiciary. Yeah, that was way back in 20 years. 15 years ago. 15 years ago.
Yeah, I worked on it, so it was in the past 15 years.
Yeah, we spent a lot of time.
So this next section, 907, is about the mental health services for inmates. And it does reference folks with the SFI designation, but I think it's also broader than just SFI. So the Commissioner of Corrections shall administer a program trauma-informed mental health services for inmates, including within 24 hours of admittance to a correctional facility, inmates shall be screened for mental illness or condition, psychiatric disability, disorder, or SFI. And this should look familiar because this is language we worked on last year. So if it's sort of ringing a bell, that's why. Inmates identified as requiring inpatient evaluation, treatment, or services shall be provided the appropriate service within 48 hours, an appropriate clinical setting, in a appropriate clinical setting. A mental health professional must evaluate inmates in a timely and reasonable fashion, including a review of medical and psychiatric records when an inmate has a history of mental illness, has received community rehabilitation and treatment services in the past, or shows mental illness and SFI symptoms. Inmates determined to have mental illness or SFI shall have a mental health provider develop and implement an individual treatment plan in accordance with best practices. Inmates shall have access to follow-up evaluations, crisis intervention, crisis beds, residential care, clinical services provided to the general correctional population, services provided in special needs units, and discharge planning services. Procedures to identify inmates who have not received appropriate services. And there is a requirement for training for medical and correctional staff to identify and address inmates with a mental illness or SFI. Then we have access, language about access, that the commissioner shall ensure inmates receive notice of available mental health services in a manner in which those services are available, and the manner in which the services are available to those inmates. And that brings us to the end of the legislative language. I don't know that we need to go through this timeline. It's more fun facts if you're wanting to do more reading later.
So the reason I wanted Katie is to see how this would dovetail. We do a forensic facility within DOC and the restoration of competency. Or if a person that's not guilty by reason of insanity. I mean, how does this play into that whole forensic facility piece, competency, everything that goes around with it? I don't know if it augments this, it's in conflict. Just, I think we need to be aware that we have a lot of statutes that deal with mental health. Granted, it's mental health. So that's what I wanted to put on the table for folks to think about. See, coordinates or doesn't coordinate, maybe work with legal staff, does it coordinate or doesn't work? Well, can you post that?
Just, sorry.
It's not
Wait,
coming,
oh,
it's not coming in.
sorry, I heard it. I think that's pretty cold,
Are
sorry,
you
no, I'm
nervous?
not, no.
It's not gonna come get you.
I,
The wind's not blowing.
no, forget I said anything.
I think he's expressing a phobia.
So,
Well, I've had that happen before, I'll swear that my window.
Where the rain can get you?
you know, yeah, we all got. We even had the sun move open. Really hard. So, anyway, that's why I wanted Katie to go through this, to let folks know there's already some things on the books.
Really helpful.
This. Do folks want to go through any of the timeline on these legislative for? No? Yes or no? It's,
I mean, I'm already going through it, but we can.
I know it's the end of the day. So this is all with SFI in terms of monthly reports. Just dealing with
This
SFI.
is mostly SFI here on the timeline. Mhm.
So I think I understand. So involuntary medication would never be administered within the walls of a correctional facility. That would be the case, the transfer, right?
That's an interesting question. Hold on, let me pull up a slide. My computer also might die soon. I've been committee hopping, so my screen has been working overtime.
See, I thought it could, but now I was thinking maybe it couldn't.
No, I think it can, and I remember John Borchak wanted another path that was easier, and we refused to do that.
Let's see. So this slide is about involuntary medication.
I think they can do it, but you have to go through the same process.
It's the court, it would be a court ordered process. So each of these columns is a situation in which involuntary medication can be administered with a court order. And I feel like there's something with DOC right here.
Corrections.
Okay,
We gotta make it bigger.
okay, sorry. I can see it fine, nobody else can?
Corrections.
Okay,
As a convicted felon, that's interesting.
Where do you, oh, second, third row?
a person in the custody of the Commissioner of Corrections as a convicted felon. The person is held in a designated correctional facility and DOC and DMH have jointly determined that involuntary medication is appropriate. What it doesn't say is where that medication would be administered, just that the person is in DOC custody. So that would be a question for DOC and DMH, if somebody falls into this category where the medication is administered.
Why would being a convicted felon be
Yeah.
relevant in that case? And
And how old is this? I mean, to use the term convicted felon. Old terminology.
You know, it was amended maybe 10 years ago, but I don't know what was existing and where the add-ons were. Do you want to look at this? This is the involuntary slide deck. Do you want to,
Don't know if I want to confuse the.
Okay.
What's the IT?
application for involuntary treatment? That's the court, yes, which is different from AIM, application for involuntary medication. Those are two separate applications that the court would rule on.
Are those the only two?
That the court would rule on? Yeah. The AIT, the result would be that they don't meet the statutory standard, or they do, and the court could order an order of hospitalization, an OH or an ONH, order of non-hospitalization. Order of non-hospitalization could be to a facility like secure residential, or it could be you have a treatment plan with the DA and you show up and you take this medication. So it could look.
And one of the things we talked about with this bill is, and the Defender General was opponent of this, putting together a crew not dissimilar from parole and probation, who follows those people to make sure proactively that they're following that treatment.
That's on in the community, right?
Yeah. To maybe get ahead of some of the recurring problems when people have been released to the community
Mhm.
and then follow up with that.
Mhm.
Kevin, you had your hand?
Thank you.
Just to follow up on that, that would be only folks that are coming. Oh, that's what you're saying, because the forensic facility would only be folks coming from the correction. So I take the point. Okay.
Yeah, there's no law for it, anything like that. He just said it was a good idea. There we go.
So I don't know where to go from here. I'm fried.
Okay. You have me for 13 more minutes.
Somebody who works as hard as you do, you deserve 13 minutes off.
Amen.
So Katie,
Thank you, Katie.
I'm just trying to figure out how to go through this bill. I did have a conversation with Representative Ward. Started taking this.
Mhm.
There was a conversation with Representative Black because of. So he
Should,
she's gonna look at the bill. I said there's mental health implications here. So we're gonna try to coordinate those two committees.
should we at any point have the healthcare, the Human Services Committee, Judiciary, and us all sitting together? So that hopefully at some point we're kind of going in a direction instead of everyone taking their view from there. I'm just afraid we're gonna, at the end of the day, be on 5 different pages.
I hope we're not. I think that would be real. I know what you're saying, and it's just thinking time wise, cumbersome wise with 44. I know Martin came to me this morning. They're gonna have new language in terms of the front end of the bill, who goes into the forensic facility. He's gonna have that, he said, towards the end of the week. And I think the other two committees are kind of waiting for that language. I think for us, what we need to do is really focus in on corrections, looking at kneeling there. We really need to know what's going on in my mind is just thumbing through the bill. Who does the forensic director? Where does the person housed? To whom does that person answer to? I think that is one important piece. I think we also have to look at the role of the Commissioner of Corrections, and what was going through my mind as the Commissioner of Dale was talking. It might be good for a few members of the committee to sit down. Maybe three members, 4 members of the committee, sit down with the Ledge Council and, or just independently, 4 people get together, the committee, and just go through the bill. Language, line by line, what are the duties of the Commissioner of Corrections? Display that out. So that we know what the duties of the Commissioner of Corrections is, and that's 193. So will then help us tailor our questions and focus in, is this appropriate for the Commissioner of Corrections to do? Or should there be consultation with other commissioners, or should there be joint custody? I mean, just so that we know what's being asked in S-193 for the duties of the Commissioner of Corrections. And Brian's scrunching up his face. And then I know Troy and Connor.
All right, well, I'm happy to do that. That would really help me get my head around the bill a little bit better. When, though, are we anticipating new language, and will that new language change any of the correction stuff?
It's not, it's the front end in terms of who comes in.
Okay, so he's not messing
It's
with.
us, it's dealing internally with a facility.
Yeah, I remember like when the state hospital was closing, they were looking at different models to avoid the IMD designation. And some of those were like a variety of 16-bed facilities around the state, but that was determined. It would essentially count as the same facility despite being separate like facilities. So I guess a question, I haven't heard anybody say it on the record. This is being motivated by the IMD rule and the Medicaid dollars. I know it is, it must be, because that's what the plan was last time. So I guess the question I would be interested.
and notification out in the public when someone's released.
Yeah,
Because if they're released in the mental health board, the public's not notified.
HIPAA.
If they're released out of the corrections board, they're notified.
Yeah.
So that's playing into
It definitely is. And Katie might know this, but I'm just wondering if there was either a unit in a correctional facility or a standalone facility within the walls of like in Springfield or wherever,
Well, that's what the
would that
Commissioner
count, would that
Dale-
count towards the designation, right? Like,
That's what the
yeah.
Commissioner Dale was saying. One of the facilities, the perimeter around it was DOC, but inside it was all.
Like, that's something I feel like I could maybe get behind.
It moves me in a good direction.
Brian, that's scrunched up his.
Yeah, I was making a face, I might as well talk. I was just thinking about the idea that we're gonna be talking to DOC, and yes, that makes sense, but what we're really talking about is the way in which care is provided, and isn't it better than to talk to somebody from WellPath, like a national
Well,
person?
we're getting well past.
Well, and then my other question though is, I want to hear about that, and I love having my finger in that pie, but does that belong to us, or does the healthcare portion of it belong to human services / healthcare and not
That's
us?
where we gotta.
That's what I said.
That's where we gotta coordinate, but I think we have to be the leader in this, because we're the ones who are really more focused on the correction piece and knowing a little bit of the healthcare and mental health. But if we're the hub here for this.
Well, for sure. And I don't mean this as a disparaging characterization, but I think what we heard from the Commissioner of Dale today was sort of like the healthcare professionals are going to figure that out. And I think what we heard from the Commissioner of Corrections the other week was, well, the healthcare professionals are going to figure that out. And so I don't know that we're going to get that answer from DOC.
Well, that's where we work on language, because one thing that I look at on the bill, and this is maybe where they get one place that might get strengthened, rulemaking. There's gonna be rulemaking happening this summer. And it's DOC commissioner is gonna lead it. But it's in consultation with DMH, Department of Health, and Dale. But it's DOC that's gonna.
Yeah, but we better have a very clear intent of what was going to happen.
Yeah, so is it appropriate that you have DOC commissioner leading this? It's in consultation. And what do you think of these rules? That book, they consulted.
Yeah, okay. I'm presuming what I'll hear, which is not.
Yeah, but I know what you're saying, and I think we understand the corrections. And that's why I'm thinking, if there was like four of us willing, or three of us, whatever it is, to get down, go through the bill. And maybe sit with the council, or maybe not. What are the duties of the commissioner of corrections, as it's laid out right now, in S-193? And then from there, we can see, well, this is really corrections policy. Or if this really deals with mental health, which is upstairs, or this deals with healthcare. With DD, that's where we can have more specific questions for the committees, because I think they're gonna be looking to us for specific questions for them to answer.
But that was why I asked the question, if we were, and I know that's a large group to have together, but if we were all hearing the same thing, what people are saying, they may take a different stand also in hearing kind of a little bit of our world or the other pieces that go along with it.
I just don't know how you do that with 44 people. With those committees are also working on their sections. I wonder if you do it, we would have a liaison going to those committees to hear.
I'm happy to work with Troy on that, because I'd be interested in understanding it better myself.
I mean, I'd be interested in doing it too, because I want to understand it. But, all right.
Yeah, I'm making faces. I might as well.
So the four of us?
They're all lefties.
Yeah, I don't hear any R's there.
What you say?
They're all lefties. Well, I don't know.
Speak for yourself, you can, yeah.
Speak for yourself.
I mean, I want to get a better feel for what is being asked of the commissioner before we can take any further action. We really need to know, because I think there's a lot of responsibility here, just thumbing through it for the commissioner of corrections.
There's a lot.
There's a lot. I think we need to list all of that out, so we really know what we're dealing with, and some of it may be appropriate, and some of it may be totally inappropriate.
And then I'm back to all the way back. If we don't approve this, if we don't agree on this bill, are the individuals who need the help better off or worse off? I know we want to do it right, but if we don't do anything, are they better off or not? Because we're kicking the can down the road for another year.
Well, the forensic facility does not come into being until 29.
So
28.
3 years.
28.
28?
Mhm.
Is it 28? What is the 29?
That's an annual reporting requirement.
28. January 1st, 28. So that is about a year and a half. But you gotta get the rules in place first.
I think we should do it and do it right. I think we're up to the task.
I want to do it right too. But if we don't do something, what's currently happening will continue to happen.
I agree.
And that's my question. So are we better off having something than nothing?
I don't think that's a choice. Let's get it done.
Either way, you get January 1st of 28. Something will be put in place. The question is, what is? Is it as the bill is written, or is it something better? So from then until January 1st of 28, people are gonna stay where they are. And there may be a few more. That's the way it's written right now. But you can't promulgate rules in 2 weeks.
Nope.
That's about an 8-month process. Anything else for Katie? But she has a hard stop here for it.
Thanks, Katie.
Thank you, Katie. We're gonna have-
Really helpful.
Writing what?
The bill.
In the, when did I start writing it? December, November.
So is this more, in dealing with a forensic facility piece, Katie, I'm just trying to figure out, dealing with the forensic facility piece, the structure of it, how it's operated. Is that Eric? Is that you? Is it a combination? I mean,
I think that's more me. To the extent we're talking about medical care that somebody is receiving, that's me. To the extent we're talking about judicial processes and the constitutionality of the holding of the individuals, Eric is staffing that. Yeah, to the extent it's healthcare in a correctional system, I can help you.
so we know for scheduling. Yeah, you're keeping track of our agenda. We're doing a lot this week.
I'm not keeping track of your agenda.
Sure, because we're doing a lot this week.
Put it on your to-do list.
You were a rock star.
No, we are starting.
Got enough going on.
We are
You can't keep track
I
of
mean, we've
everything.
got,
That's what you-
we've got the Commissioner of Mental Health in tomorrow.
Okay, I think I'm booked solid tomorrow morning.
Yeah, and then we have the Commissioner of Corrections coming in. And then in the afternoon, we've got, WellPAP is coming in tomorrow afternoon. Okay. And then Thursday, we have, the network is coming in. Legal aid's coming in. And, then we're gonna be on the floor on Thursday afternoon. Part of Friday morning. So just if you could just take a look at our schedule.
I would be happy to take a look.
I know you're tired.
Might be. Don't know that I can make an appearance, but I'll look at the schedule. Okay.
You know what's happening.
Yeah, okay, yeah.
Alice, is
Katie.
it possible, can we ask, be able to make one statement? Is that okay? or not?
Sure. I just wanted to add, first of all, thank you for the discussion and everything. But when you do look at the bill and you get into section 7, you see where it talks about October 26th, where October 1, where they're going to come together with some proposals. So I know you're looking for a lot of information from DMH and DOC on the plans of who's going to be, what is the, the care going to look like, where's it going to be, and all of those details. But I don't think they've put that together yet. And you can ask them tomorrow, because I think what they need first is the go ahead that this is going to go forward before they put all of those hours into the details. And I know that they have said that they expect that if it gets to be too tight for October 1, they would come back and request additional time. So I know you're looking for some specific answers, and I'm just not sure that this is the right time, just based on what I have heard from experts who have testified and
So
everything.
I think this was part of what they worked on over in the Senate, but they wanted to have the structure of how it was gonna operate before it actually hit the bill.
Yeah, they wanted to get the go-ahead to do it. Then they were gonna start working on the details because they know that you have 2 years. And I mean, I know it's 28 that is coming in, 29, but it will probably get delayed. And, you know, people cannot stay in jail for 3 years waiting for an evaluation. So they will be getting released back into the community and things like that. But I just think that they're gonna have that you know, once you give them the go-ahead, I don't think they have those details because there's so many other things that they're working on. Why would you put all that time into something if you don't even know if it's gonna go forward? But thank you.
Anything else before we finish up today? So we're back here tomorrow morning at 8:30. And, before we break, anything you want to share that happened downstairs?
No, I can type up some notes, but they essentially gave the same presentation they gave here. Except it was Scott and David, the
Chair.
yeah, the deputy treasurer. I didn't hear anything new that they didn't share with our office on how they arrived to both the 50 million per year mark and then how they evaluated what it would be like to do an extra 100 million or an extra 150 million. Before we started that, I typed down some of the questions that they were asking. Not a lot of questions from folks. I did in the hallway ask the deputy treasurer if he anticipated the treasurer coming out with a position on this anytime soon. He thought maybe, probably not before the bill gets passed, but maybe within a week or so.
Well, it's over in the Senate.
Right.
Great. Thank you, Troy, for doing that.
Yeah. I'll type up my notes anyway. It's all information we all heard.
And we're doing a drive-by tomorrow. Did we hear back from the treasurer,
Yeah, David and Scott.
David and Scott?
Yeah, my guess is that they're not gonna have a lot of information, nor are they gonna be willing to go on record as to whether or not they'll have a position on it.
Anything else before we break and get off of you to go?